nomination, your lordships, as a candidate to election on the pretext that I hold
For
as
bar
president
election.
for bar council.
Very good, very good.
Your lordships, it is for the reason that I am president of the bar. Your lordships have already passed that order that
While an election,
is
you must remain busy throughout the year.
Your lordships have already passed the order. May I just pass this order? Your lordships have already passed.
That order I
Yes.
Yes.
Your lordships have already passed this
You
order.
can also rely upon if the order is already there.
The issue is the Bar Council of India has not amended this rule, your lordships. Your lordships has already said then the office bearer cannot be the it cannot be an hurdle from contesting an election. Now I am the president of a bar association. Only because
consider the direction is already there. Once this rule is revisited by them, it will apply uniformly to you also.
Yes, so as of now they have not amended this rule. So therefore my candidature is now cancelled.
Let them have some breathing time and
your lordships, I have filed the SLP. If your lordship will direct the SLP to be listed tomorrow, your lordships. Yesterday, the supervisory high powered committee have rejected my contention.
Well, we'll see when your matter is listed.
Item 2, my lord, is early hearing application, my lord. Item 2, we have filed early hearing because there is stay order which is operating and 550
Early hearing in what?
of appeal, my lord.
Admitted item.
It is admitted in item 2, my lord.
Number 1%. To entertain early hearing.
That's the only reason I am mentioning, my lord, because insofar as that stay order which is passed by this court has resulted in a stay order around 550.
We will examine ourselves. We will examine those matters.
Please, my lord, kindly.
If I may mention,
Lordships, I am the chairholder of the Secretary of the Bar Council of Maharashtra State Bar Council. I am lying on the similar footing, Lordships. I filed my SLP today. May it be tagged with together and listed tomorrow, my Lordships. If you
There is no question of listing tomorrow if you have filed it today.
Lordship, the urgency is that the Bar Council of Maharashtra is contesting the election of 24th of this month, Lordships.
Let it be. You should have come earlier.
Your Lordship, if I may mention, this is a fresh SLP I filed on Monday. An urgency letter was moved. There's an exemption from surrender that was filed.
So filed on Monday.
Yes, Your Lordship, it's not listed. It's listed. The tentative list is showing for
filed on Monday. Have you cured the defects?
Yes, Your Lordship, the defects were cured and exemption for surrender also filed. An urgency letter was moved. But the date is showing as Monday, even though the petition has to surrender by Sunday. The stay that is granted by the
Just
order is pending.
Your lordships, I'm sorry, your lordships. The election petition matter, I just mentioned, your lordships. Yesterday, the order was passed. Yesterday, the high powered committee has ordered passed.
Well, fine, not before Monday.
Your lordship will have it tomorrow.
No question of listing tomorrow. There is nothing.
Then your lordship will have it on Monday, your lordship.
Item 8.
Yes,
obliged.
My lords, item 8, we had circulated a letter to bring the counter affidavit on record. However, it was not taken up on record because of the fixed date of this thing.
File application, how much time do you want?
My lords, we filed our counter affidavits not on record. My lords, may have it next week.
You have filed the counter?
Yes, filed the counter affidavit.
Then State Council informed that counter affidavit has been filed. The same is not on record. Registry directly to tell the same paper book. Post the matter on next week.
Grateful, my lords.
Please, my lords.
I have surrendered. Better. Two. Lordship's order of 24-2, I surrendered on 26-2. Because I was applying for anticipatory bail, my lords. It fell from your lordship's surrender. We will consider. Therefore, my lords, on 26th itself, I surrendered. Charge sheets are filed, supplementary charge sheets are filed, everything is filed.
My lords, we have sought for police custody.
How can you file after filing charge sheet? Where is the question of police custody? This is some new law.
In the course of further investigation, for an accused who was not available, he's now been arrested. We've sought police custody. He's filed his opposition to that police custody. The learned magistrate has to consider it, and orders are reserved already. So the police custody remand will have to first be considered, is our submission.
The order has been reserved.
Reserved.
I am praying, my lords.
As of yesterday.
My learned, I am praying when it came up for your lords, before your lordships, my lords, the first time, this time on 24th, it fell from my lords that instead of staying in Sri Lanka, I better surrender and I come here. Then your lordships may consider my prayer for interim bail and bail, which I did within 2 days. I gave an undertaking, I will come back, and I did that.
So let us see first of all what the court decide about your custody.
It doesn't lie. I mean, after charge sheet supplementary, under which provision will it be
They can
provided
file
for,
a
my lord?
supplementary charge sheet, Mr. Dave.
I-
You can make the submission before us.
No.
Under which provision?
Yes.
We expect that you would be knowing the provision.
After filing of charge sheet,
Yes, after the filing of charge sheet.
for police custody,
Yes,
we can't.
sir.
No, my lord, both
This
cast,
court is having.
both
Go back
Kaskar.
and read Dinesh Dalmia.
Yes, Dinesh
Dalmia-
Dalmia and Kaskar, my lords. I have read Dinesh Dalmia, my lord. Lordships may take it that I have read it. It is for an accused who was absconding, for which further.
You were absconding, you had a lookout
I
notice.
was before your lordships, my lord. That's why this order came to be passed.
Whereas you came much
No,
later.
that's why this order came to be passed, my lords, that it will be, your lordships may consider regular bail, including interim bail.
Very good.
Now.
Well, in fact,
and-
now
my lord,
that
can
he has
we consider
surrendered,
this.
the
I have
double
surrendered-
court should follow.
We are informed that after that the petitioner has surrendered in terms of order dated 24th February 2026, and thereafter his full police custody has been sought. The orders, thereafter on the issue of a requirement of petitioner's custody by police for interrogation, you might have been argued before the judicial magistrate and the order is reserved.
Please.
Next. Professor Gordon.
Lordship, please.
I am obliged.
Next week.
My lords, I think 10 similar matters are pending before your lordships with regard to this West Bengal SIR.
Okay. Why people are filing and
My lord, I am a MLA from West Bengal, so
you had to know new paragraphs and
my lords, the main matters are coming up on 24th of March.
whatever date is coming.
Let this be tagged along with the main matters, my lords. Let this be tagged along with the main matters which is coming up.
That we have done.
24th.
We have done it. We have done that.
So,
Oh, are you? गुम हो गए थे
मतलब
आप तो रोज ही कोर्ट में खड़े रहते हो आप मैंने कहा पहुंचाने में देर लगी आपको कहाँ थे आप
नहीं I practice in Lucknow malad, so that I don't know the
नहीं आप आते रहते हैं
sometimes
आप नहीं आते तो हम बुलाते रहते हैं
sometimes I dare to come malad to the Supreme Court. But the
Yes,
order
please tell us.
the order passed by the High Court. Order passed by the High Court through which my petition claiming rupees 1 crore as a fee and expenses for filing the 6 cases to defend the then Honorable the Chief Justice Honorable Sri
But you
Deepak
have been
Misra.
acting in person so you have not incurred any expenses.
The expense was at least 2 lakhs. And at that time, I was my entry in the High Court was prohibited, and so that I took this money from my daughter to defend to file the cases and until the motion was not rejected by the chairman. I didn't file any petition except on the seat on which Lordship is sitting, Honorable Judge Deepak Misra was sitting. I made at least 15 mentions for his lordship for getting the defect removed.
After making left and right all kind of allegations, why you are using the word honorable now?
Malad?
Where did you left the definition of honorable now?
Malad?
After making all kind of nasty allegations against a sitting judge at that time.
Malad?
Now you are.
No, yeah, Malad, what I'm submitting is
Huh?
I was submitting it that Malad, the judges cannot address the press conference against the Chief Justice saying this was against the norms. In case he would have been some IS officer, some any other officer, you would have dismissed from service immediately.
Mr. Pandey, you provided social service to the institution.
But even then I have a stomach.
You provided social service to the institution, and for social service is always priceless. How can it be assessed as 1 crore, 2 crore, 3 crore?
I have to pay some cost to the Supreme Court. One day, and you have the order passed by Supreme Court. I was picked up from my house at
Cost of
blood for recovery of cost of rupees 1 lakh. I was picked up at 8 a.m. when I was doing a prayer in my house, and they left me when the recovery of
that we are aware. You have lot of litigation in your family, and some persons are there. Lot of FIRs, cross FIR. Those matters have been coming before us. Those have nothing to do with the petition which you filed with respect to the alleged rescuing of a judge. That you have done a social service. You want an appreciation. We appreciate for that. And you continue to do your work. Thank you very much.
Please, Kali 1 minute, Kali 1 minute, page 135, please see the order on the ground of which my reference made by the president has been rejected by the law ministry. I am permitted to read that. Please see that. Please say that ground, on page 135, please,
Yes, read.
Payment of fee and expenses for filing 5 cases to save the Honorable then Chief Justice Deepak Misra from torture, insult, humiliation, and removal. Regarding, sir, please refer to your undated letter concerning of the subject mentioned above, which the department has received from the Department of Justice according to their office memorandum such and letter through the President Secretariat as per the letter dated such. Regarding the matter, it is important to note that the government of India has an extensive, exclusive panel of advocates at the Supreme Court of India to represent the government interests, and that you are not included in the panel of this department as the Supreme Court of India. When this petition was, when this impeachment proceeding was going on and the Chief Justice of India was being insulted, neither the Attorney General came forward, nor the Solicitor General came forward. And this government of India is saying that we are having extensive panel. In case I moved the application for the initiation of the criminal contempt proceedings against Mr. Kapil Sibal. Please permit me. In case Mr. Sibal, the Attorney General would have granted that permission to prosecute me, he himself would have started prosecution. The impeachment motion for removal of the Honorable Justice Deepak Misra would not have brought. But it started when the application for filing the criminal contempt was rejected by the Attorney General. The government is saying, they are saying that you have not done anything. Plus, suppose that I am doing something, and in lieu thereof, some public servant and top-ranking public servant is being saved. The appointing authority of the Chief Justice of Bharat is the President.
We have heard the petitioning person at a considerable length. The claim which he put forth before the High Court and which has rightly been rejected, is totally misconceived and misdirected. No case to entertain this specially without dismissal. That's both of you. Thank you.
That is the cost incurred in my. At least I am having also.
Thank you very much. Continue to render your social services. That's all.
But for that, the funds are required.
Thank you.
Obliged.
Please, my lord. My lord, the petitioners are all farmers whose land was acquired, about 1,000 acres, between 1994 and 2000, and given over to a private company with the stated public purpose of creating an industrial hub, a thermal plant, and a chemical plant.
Compensation then, if you are challenging.
Not all of us have received compensation. There's part
compensation was paid in 2017. If it is not paid, that can be pursued. And Madam, see paragraph 143. Your interests have been protected by saying that from every family will be given a
That has not happened, Lordship, because there was
It's not happened, madam. The answer is a contempt petition, not an SLP before the Supreme
Lordship,
Court.
if I may just clarify that. The industrial project is now being shelved through a share purchase agreement. It's been given over to a builder.
Follow it.
So
If
there
that is so, then there must be a recall or modification of paragraph 143.
My lord.
What the High Court held was the share purchase agreement, however, is subject to the terms of the MOU and it will be treated to be an industrial undertaking.
Lordship, on the contrary, the impugned order goes beyond the MOU.
Understand.
If Lordship will...
We understand what you are saying, but the thing is, ultimate directions, you see, there is some confusion in reasoning.
Lordship...
Section 41 of the Land Acquisition Act has been ignored.
I'm obliged.
Right, but ultimately what the High Court does is to your advantage.
Lordship, if Lordship will just have para 89. There's wilderness, Lordship. There's a jungle growing. Out of the 1,000 acres, 400 were later denotified. So it's about 600 plus acres, out of which 98 has been developed somewhat. The rest is wilderness.
Are they developing as a township? Or they are developing as a chemical plant?
Private builder, Lordship. Private builder for residential purposes. Only for residential purposes.
See, is somebody colluding in government? Why some politician must have colluded with this builder?
We would be very eager to give a notice if PUDA had come before us.
Lordship,
PUDA.
I cannot suffer for PUDAs. They were there in the High Court. They also filed a review.
They cancelled it.
Issue notice.
I'm very grateful. Would Lordship consider granting status quo on the land, because there will be alienation?
According to you, they are not doing anything on this spot. In 1 month, what they will raise there?
Let there be status quo, Lordship, because if there are further alienations, then I will suffer.
You will suffer. You have no right on the land. At best, you might have some more enhanced compensation.
Lordship, I will pray for...
No threat.
I'm obliged, Lordship. I'm very obliged.
Please, Your Lordship. Lordship, in similar matters, my lords have given direction to approach to the competent authority. My lords, but there is one issue which I want to raise before my lords. My lords, kindly turn to page 68, my lords, of order input, my lords. Page 68 number.
Whatever issue, additional issue you raise, that also.
No. I am not, so, sir, I am not raising any additional issue, sir. Sir, actually, there is a direction given by the High Court that actually we are not inclined to interfere in the matter because there is the undertaking given by the government of Rajasthan to hold the election prior to 15th of April 2026, my lords. But my lords, they are not holding the elections as of now, my lords. And they have approached again to the Honorable Apex Court, my lords, for extending the date, my lords. They are not holding the elections, my lords.
Please appreciate if the High Court direction for conducting election in a time-bound manner is not being honored. For that, you can go to the High Court with a contempt or whatever action.
No, sir. Sir, they have given undertaking before this Honorable Supreme Court of India, my lords. Honorable Supreme Court, they have given undertaking, my lords. It has been mentioned in order input, my lords. It is very well mentioned, my lords. Page number 68, my lords.
In any case, in the matter where this undertaking was given, you can take action as per that.
My lords may given the it may be given direction. I will take appropriate action. They have given undertaking, my lords, before my lords. They have given undertaking, my lords, before Honorable Supreme Court of India.
No. In which matter it was given, that in that matter you can take appropriate action. We are hinting you.
Sir, our matter was not heard on merit by Honorable High Court, my lords, for the reason that we are disturbing by filing these petitions. That's why they have given a specific direction because you are disturbing the actual elections are to be held prior to 15th of April.
Next paragraph. Counsel for the petitioner has also pointed before disposal. One more paragraph. Counsel for the petitioner has further pointed out the operative part of the interim judgment of the High Court, where it is mentioned that the authorities had given an undertaking before this court to hold Gram Panchayat elections by 15th April 2026. It is stated that no process for conducting the elections has been commenced so far. So if that is so, the agreed parties shall be at liberty to seek redressal of their grievances in accordance with law. That's 14.
Please, Lordships. Lordships, High Court rejects the nomination made by the petitioner, and that nomination, my lords, High Court directs me to select me from the panel curated and controlled by the respondent, which is contrary to the judgment of this Honorable Court in the Constitution Bench Judgment Court. The same issue, my lords, High Court relies on Vilupuram Highway judgment.
You are also adamant that you want a particular bureaucrat as your arbitrator. Why couldn't you request to the High Court that High Court can appoint some independent arbitrator?
My lords, that was, my lords, but they are forcing me to select us from.
They are forcing, you don't want. You are also forcing them to, you are a handpicked person who is a former bureaucrat.
That is the mandate of the contract clause, my lords, 38.3.
There is no question of contract. Then go for contract. Why are you coming to court?
The mandate of the contract, you go into the Sarod rules.
My lords, the Sarod rules issue, my lords, is pending before a bench of this Honorable Court.
You have enough money to spend on litigation, frivolous litigation.
My lords, I understand.
Instead of, you could tell the High Court, I am not accepting their arbitrator. They are not accepting my arbitrator. You please appoint someone independent person.
Well, but by forcing me to go for Sarod, my lords, I am being forced to select an arbitrator from
retired High Court Chief Justices, retired Supreme Court judges are in the panel of Sarod. You have seen the nomination made by your respondent.
My lords, the entire issue therein, my lords.
Nominate here.
My lords, the High Court has relied on a judgment. This issue regarding the validity of Sarod panel, my lords, is pending before this Honorable Court, my lords. The same issue, my lords. They have relied on Vilupuram Highway's judgment.
Pending, sir.
My lords, this will have
decided there. But if, in our estimation, the standing and the stature of the members in the Sarod panel completely dispel any doubt of curation.
My lords, but the Sarod panel, my lords.
That's what we are saying.
The Sarod panel, my lords.
You want an arbitrator of members is in your pocket. That's all.
My lords, but then set it back to the High Court.
Let
us appoint an independent arbitrator, my lords. We being forced to appoint a Sarod panel.
Yes,
which is curated. Sarod panel, my lords, a panel which is curated by the respondent corporation, my lords. That is specifically been disapproved by the Constitution Bench of this judgment. of the some particular court, my
Number
lord.
of judgment.
Para 168, my lord, so that of the court judgment, my lord, specifically disapproves because they have relied on voestale-pine judgment.
There is
Voest-
no deep pervasive control of NHAI on Sarod. And again, we are reiterating, sir, the stature, the reputation, and the respectability of the members in the panel are absolutely above board.
It's identical.
Para 37 of the Act.
Yes, my lord, that's the my lord. Para 37, my lord, about my lord, para 37, my lord, may I have para 36 for a moment, my lord, para 36. Para,
You read 37.
yes, my lord, para 37, my lords.
Yeah.
I'm bowed down, my lords. I've seen that para 36 is the operative part, but just prior to that, they draw reliance from para 36 of the judgment in Vilupuram. Vilupuram highways, my lords. For a moment, my lords, page 18.
Ignore Vilupuram. We ignore
That is pending
Vilupuram.
before this-
Again, we are repeating to you. Nothing is straitjacketed. When it's a question of bias, when it's a question of equality of arms, it is to be seen who is the arbitrator concerned. And if the arbitrator concerned has a reputation of standing before a section 11(6) court, we have no doubt that there is a question of bias.
My lords, Vilupuram, my lords, specifically, my lords, they have relied.
Vilupuram will be decided.
My lords, they have drawn, my lords, they have drawn in the reliance from Vilupuram highways. My lords, I see para 36.
This institution of arbitration is being destroyed, and with the active support of the lawyers and some the arbitrators who are
May my lordship's attention, my lords, to draw lords para the clause 38, my lords, of the arbitration clause.
If these were not acceptable, you could request the High Court that, well,
Yes, my lords, may I send it back to the High Court for considering that, my lords, so that we can have an independent arbitrator. My lords, we are being forced to select an arbitrator from the panel.
There is nothing like
My lords, clause 30, my lords, clause 38.
Party
Sir,
autonomy.
there is no force.
Party autonomy does not mean that you keep a pocket your arbitrator and say that this is the person.
That is exactly what we are saying, my lords, because they are selecting.
Also to.
They are selecting from the panel, they're forcing us to select from their panel. My lords, clause 38 says we'll nominate an arbitrator, they will nominate an arbitrator. The third arbitrator will be according to Sarod rules. But High Court says no, everything has to be done according to Sarod rules. Even the first arbitrator is to be appointed by the Sarod rules.
An arbitration dispute with the National Highway Authority of India. The petitioner contractor wanted to appoint a former bureaucrat as the arbitrator, as its nominee arbitrator. NHAI did not accept such nomination. The matter nomination and requested and insisted for appointment of an arbitrator out of the panel of arbitrators maintained by the Society for Affordable Redressal of Disputes, in bracket Sarod. The petitioner objected to the nomination of arbitrator from Sarod panel and consequently approached the High Court. Its writ petition has been dismissed by the improved judgment. We find from para 37 of the judgment under challenge that the Sarod panel is a broad-based list of empaneled arbitrators that include former Supreme Court judges, former High Court judges across several states, retired secretaries to Government of India, members of the statutory body such as NHRC, senior engineers, financial experts, and other professionals of high repute. In light of this, it is totally misconceived and misdirected contention of the petitioner that it is being compelled to directly plea that the party autonomy is being compromised. In any case, nothing precluded the petitioner to request the High Court to appoint some arbitrator, independent arbitrator of the High Court's choice. We therefore see no reason to interfere in the interim judgment of the High Court. We have our grant liberty to the petitioner to move an application before the High Court with the prayer that some independent arbitrator from road panel and or otherwise, as per the choice of the High Court, may be appointed.
Is the arbitration clause the Sarod or any other arbitration rules applicable?
That's what you have said. We have said that we leave it to High Court.
Sarod part, because we may appoint on the High Court panel, my lords. That's
We leave it to the High Court.
Wait, please, my lords. Wait, please, my lords. My lord, this petition is related to the UGC regulations, which is already in the consideration of this honorable court. But this PIL is fundamentally distinct from those writ petitions because those primarily focus on substantive definitions of 3C, while this present petition has primarily focused on procedural and enforcement architecture. My lords, it was filed on 13th of January. It was.
Yes, I have the order.
Direction to give so
Obliged, my lords.
May it please, your lordships. Lord, this petition is challenging the constitutional validity of Section 129 of Transfer of Property Act, as well as Section 2 of Shariat Application Act 1937, so far as the word gift is concerned. Lord, the scheme that is being laid down in Section 129, the conclusion, the repercussion of that is Muslims are exempted from paying stamp duty while non-Muslims are not. Other than that, my lord, this particular section, since registration is not mandatory for Muslims, it also causes uncertainty in land records as well as in litigation as well. Lord, may kindly have Section 129 for a moment.
What is your problem? What is your problem with 129?
Lord, the grievance here is that by virtue of
for any exemption.
No, Lord, by virtue of Section 129, read with Section 2 of Shariat Application Act.
Except you are saying that there is a loss caused to the public exchequer.
That's one point. But here I'm challenging it at the threshold of Article 14 and 15 also. Because by virtue of this, when we read this conjointly with Section 3A,
first of all, if there is a loss to the public exchequer, what prevents Parliament is the competent forum. Parliament can always amend the law.
Lord, that's
Parliament can bring a new law. Parliament can amend the law. Parliament can suitably modify it. Whatever way they want, they are the competent authority. They can do it.
Very well, Lord. But my grievance here is that by virtue of this section, Muslims are exempted from paying stamp duty, while the same favor or same exemption is not granted to non-Muslims. When we read this, when we read Section 129 conjointly with Section 3 of Stamp Act, as well as the Section 17 of Registration Act, Lord, since registration is not compulsory for them, consequently they are not liable to pay stamp duty. Hence, the loss caused to the exchequer is my third point.
For Mr. Consul, what prevents you? First of all, you should have gone to, why didn't you represent a single parliamentarian pointing out to them that look here, in the law, which is pre-constitution, there is some element of alleged discrimination as you are proclaiming, and therefore you bring to the notice. You sensitize them. They are public representative. They will understand what is wrong and what is right.
No, the answer to that question is there is an interplay between Transfer of Property Act, Stamp Act, as well as the Registration Act. Because of that interplay, this honorable court may decide this dispute, because unless that
when the matter involve amendment of a provision, striking down of a provision, what prevents you, and why have you not chosen to approach those parliamentarians who are competent, who can take up this issue?
Because, my lord, the clash between personal law and fundamental rights, so far as the concept of gifts is concerned, has to be determined by this honorable court. Not there is an interplay between these three legislations, and this situation has needs to be
We will determine only when somebody shows bona fide, first of all, approach here and there, you knocks all the door, and when you find that you are not getting 1882 law, suddenly in 2026 you have remembered that it violates Article 14, and when you remembered it, you didn't deem it appropriate even to inform those persons who are the best one to rectify.
But not by virtue of section Article 13(1). This I'm relying on that because both of them being pre-constitutional laws, they are already hit by Article 13(1) and they are void to that inconsistency. Hence, Lord, I approach your lordships for this.
So therefore, what prevented you, first of all, tell why have you not approached anyone?
Lord, because
coming after 75 years of independence.
Lord, I'm 30 years old.
2026. Please tell us. Every day the PIL.
Lord, the problem here is that
to approach someone.
Lord, there's one problem. The personal law, the clash between personal law and fundamental rights here, as so far as it pertains to gifts not being an integral part of the.
Right now, commenting anything on the merits, that is, you are apprehending that the plea of personal right, personal law, any XYZ will be taken. We are only on the peripheral issue at this stage that suddenly for challenging a law enacted in 1882, which is in force for last 75 years when the Indian Constitution came into force, you have chosen 1920-26 because in the fine morning you find that this law is offending certain provisions. So what prevented you at least to inform the lawmaker that look here, this is one provision which might have escaped your notice. This is a provision which probably required to be revisited by you.
Very well.
The reasons, maybe they agree with your reason. Law Commission. Best for me, Law Commission. Every day, the Law Commission make recommendations for suitable changes, bringing new enactments, where you could also represent.
Very well, not, but so far as this intertwining between these three
it does not come in the news. That is the problem.
No, Lord, that is
the biggest problem.
That's not my motivation, Lord. I have 7 to 8 years of practice, Lord, as officer of this honorable court.
Counsel, you are right, but the thing is, when you see 129 and 123, you have to examine it both from the end of the donor and the donee.
Very well.
Right? So, if you see from the donor's point of view, you are making out a case of discrimination on the point of religion. But a hiba is not in respect of a donee religion specific. It can be to any other faith or a person who is a non-Muslim. So if that is so, when the donee is a non-Muslim, whether the hiba being carved out of as a special species of gift and non-registrable will be a reasonable classification or not is to be first examined by the Law Commission.
Lord, there is no intelligible differentiate there. The reason why I say this, one, the concept of hiba is 1400 years old when there was no system of registration or anything to be reduced in writing. And two, Lord,
foremost you are making a fundamental error. It is not 1400 years which is relevant, but hiba, even in respect of an immovable property, can be by way of an oral declaration.
But Lord, that would the repercussions would be massive. For example, Lord, may I
one thing at a time. The question you have posed is one of religious discrimination. When the donee does not have a religious identity, can the giver give to someone else be identified by the religion of the donor? This is one question. The second question with regard to your loss of revenue is a matter of classification where an oral declaration or bequest is kept apart in contradistinction to written instruments which require registration. This is a reasonable classification. Thirdly, if you see the other area of vexatious transfers which do not get recorded is again not something which will make the law manifestly arbitrary, but may require some noting or some recording of an oral declaration, which is for the legislatures to see. So please approach the law commission. I think the law commission is the best expert to look into this.
So the petitioners have approached this court invoking jurisdiction
Lord, then
Article 32 of the Constitution. With a prayer to strike down the words inverted commas, court shall be deemed to affect any rule of modern law inverted commas closed occurring in section 129 of the Transfer Property Act 1983. The plea taken is that exemption of a gift as defined in section 2 of the Muslim Personal Law in bracket Shariat bracket close application of 1957 from the requirement of compulsory registration and consequential non-payment of stamp duty charges is not only a loss to the public exchequer, such provision does not meet with the mandatory standard of Article 14 of the Constitution. So, in our considered opinion, the appropriate recourse for the petitioners would be to approach the expert body like Law Commission of India, who have been entrusted with the responsibility of recommending suitable amendments, stroke changes in the existing laws, and of enactment of new laws, as may be required from time to time. Such an expert body being functional as of now, we see no reason to entertain this petition at this stage. The same is accordingly disposed of with liberty to the petitioners to approach the Law Commission of India.
grateful, Lord.
Lordships, I am suffering from inordinate delay, judicial delay caused by the Honorable Bench of Lucknow, Honorable Allahabad High Court. So since last 13 years, my matter is not reached, not taken up. So many times I mentioned application, mentioned the case and listing application, but there is nothing in my hands.
Matters are listed before one judge in that High Court.
Lordship, 13 years.
Look at the human beings, their conditions also. How much burden you want? It's not that we are not aware. In one or two matters, if we have put a word of advice, that does not mean that we do not know the amount of work they are performing.
Lordship, we are also aware, but it's a 13 years delay. 13 years.
If you are pending from 20 years, then why 13-year-old?
That is why, and this matter is of recruitment
Please
issue.
tell us.
My
What is the oldest
age is
matter
going
here?
to be finished. My
What is
age
the
is going
oldest
to be
matter?
finished. Yes. Kindly give me some opportunity to be heard before Honorable Court.
That's right. It is not the question that we want every case should be disposed of within 6 months, within a year. Given a choice, we would like to have that kind of situation.
Lordship, I have no recourse to come before this Honorable Court. Where I can go? Because lots of time I entered the Honorable Lucknow High Court. So many applications, so many mentions, everything I have exhausted.
One case out of track and ask the High Court to dispose of it on early basis without the turn having come. What will happen? This disposal will be at the cost of one or the other person who is sitting in the queue and who definitely does not have mean to come Supreme Court. You have means, that's why you are before us.
Lordship, it's a selection issue. It's a selection issue. My age is going to finish and then I can note. And I'm an army man family and I'm trying to my best to be serve myself as an army officer. So it's a teacher recruitment issue and my interviews were done, but the merit was decided on the sole basis of interview, not the written examination.
Concerned on merits because the issue is
Let's see. That is I requested to this Honorable Court. Kindly give me direction to the Honorable Court.
The instant petition has been filed seeking a direction for early disposal of a petition pending before the Allahabad High Court and bracket Lucknow bench. This kind of petitions are filed routinely, and this court has been extremely reluctant to entertain the same. Though such like petitions are filed routinely, this court has been always reluctant to entertain the same. The roster management of the High Court has to be left to the prerogative of Honorable Secretary High Court. It is pointed out that the petitioner is unemployed and his case for appointment of a religious teacher in bracket Molvi in the Indian Army is pending consideration since 2013. All that we wish to observe is that the petitioner may go on appropriate.
Lordship, pleadings also are completed in this matter. Pleadings are also completed in 2013.
May go an application before the High Court along with copy of this order. We request the High Court to consider the petitioner's prayer for early disposal of the case sympathetically. However, as per its own prerogative of discussion.
Obligement.
Yeah, please, my lord. Petitioner belonged to the PWD category, my lord, and he had applied for the post of civil judge in the state of Rajasthan in the year 21 and 24 under the said category, my lord. And he had qualified the mains exams in both the occasions, but he was not called for the interview. He had the minimum qualifying marks, and in the under the said category, and in the year 2021 advertisement, my lord, there were 5 seats reserved for the PWD category, but none were filled up. And in the year and none were called for the interview. And in the year 2024, there were 9 seats under the said category. Only 3 seats were filled up. Six remained vacant. And those 3 candidates approached this honorable court, and on the direction of this honorable court,
those who have been going to the right forms and seeking rightly intervention, they have got the relief. This man has been, poor fellow has been.
No, my lord. No, my lord, this is not so, my lord. My lord, in fact, he was proactive. He had approached to the High Court, though the other candidates approached this Honorable Court, and at that time he was not aware that this Honorable Court has appeared. Only when the final result came and the cutoff list came, cutoff of the final result came, then he came to know that.
Process is already over. He has not been harassed by High Court, he has been harassed by his counsels who have been misguiding him and putting him. 2022, when the matter was decided, why he should have come to the Supreme Court. 24 again, then come to the Supreme Court. The others came and got the relief.
No, my lord.
Selection process is over, everything is over.
No, my lord, what has happened in the year 2022, he approached the High Court. His petition was pending, therefore he could not come to this Honorable Court. As far as the 2024 advertisement is concerned, my lord, mains result came on 1st October. Date timeline is very important, lord. On 1st October 24, mains result came. He did not find his name in the said list. He immediately, within 5 days, on 6th October, he filed the writ petition before the High Court, and the High Court dismissed the writ petition after 10 days, that is on 16 October. And
just Nagaratna.
Sorry.
Page 9.
Page 99, Annexure 11, my lord.
Started on 15th April 25.
Yes, my lord.
146. Let this petition be listed before the bench presided over by Justice. Mention my name of my sister, Vivi Nagaratna, on Monday.
Just
Much obliged.
grateful, my lord. Grateful.
Item 19, there is a letter circulated.
My lord. Much obliged.
Yes, item 20.
Please, my lord. No, the petitioner is retired Lieutenant Colonel, selection grade. If I may point out, my lord, so far as selection grade and the time scale is concerned, by length of service.
Why can't you go to AFT? Because it is time barred, unfortunately.
It's not. I'll explain, my lord, if lordship.
So you claim the time barred
Your
because
lordship is
they
right. In fact, I also suggested my client at the threshold that he should be approaching the.
you can still make out a case before AFT.
Yes.
Saying that it's a recurring cause of action. And therefore, if the AFT, first of all, we hope that they will appreciate this part, because pensionary claim normally is a recurring cause.
Please, my lord.
But at least give us also some phase to that we can interfere if you come through some channel. Directly, it may not be, please.
Please, your lordship, my lord, please, looking at, just a moment, my name goes missing. Page 64, your lordship will have.
Page 64 for a moment, Mulad.
Directly entertaining a petition, you know very well, with your experience, it may not be advisable.
Then your lordship will allow me to approach the tribunal.
We will not allow you, we will say something that you can take benefit of that.
Your lordship will have then page 64 for a moment, Mulad. The table at the top, if your lordship.
They will say, they write down, the petitioners are retired officers of the Indian Army. They lastly held the rank of Lieutenant Colonel in bracket selection grade. So it seems that an anomalous situation has arisen in the matter of fixation of pension which, according to the petitioners, is contrary to inverted commas one rank, one pension scheme. We are, however, of the view that this is not a matter which should be entertained directly under Article 32 of the Constitution, when the petitioners have got an efficacious alternative remedy to approach the armed forces tribunal. The petition is accordingly disposed of to the liberty to the petitioners to approach the tribunal in accordance with law. As regard to the point of limitation, we do not express any opinion in relation thereto, except that the petitioners, if so advised, may plead recurring cause of action. We are trying to hint to the tribunal to entertain that we can, this much only we can do, recurring cause of action. The rest we leave to the AFT.
Yes. Lordship may say AFT principal bench. Because it is pan India, so let it be here only.
You will go and you will find the matters are not taking much time there. To the liberty of ordinance, the petition disposed of at this stage.
Please, Your Lordships. The Lordships, in this case, they are pursuant to the allegations of complaints received regarding corruption and the misconduct,
Right now.
But, Your Lordships, the penalty that was imposed was the leave of the kind due. We have considered his representation as considerably as we could, my lords. We've given him the benefit of all his leaves.
Principally, we might agree with you. We are with you. But leave it there.
But, Your Lordships, there were 4 complaints, out of which in 3 complaints, the inquiry findings were against him. Major penalty proceedings were proposed.
There were complaints, and complaints.
Please, Your Lordship. Yes. Yes, Your Lordships, they were there.
But then,
my lords, and major penalty proceedings, the stage was that. And my lords, then we went under that rule and prematurely retired him. This is the least that he can do, my lords. He must return this money.
It's all right.
As Your Lordship, please. Obliged.
We have heard Senior Counsel on behalf of the Petitioner High Court at a considerable length. In the peculiar facts and circumstances of the case, we are not inclined to interfere with the employee judgment of the High Court.
Obliged.
Your Lordship. Item 22, Your Lordship. Your Lordship, once a land which is recorded as a forest land, my lord, it cannot be, my lord, converted into something without.
must have taken unauthorized possession there of the land.
My lord.
You must have grabbed this land or
No, no, no.
persons on their behalf you are fighting.
No, no, my lord.
You
Your
should
lord.
have something at least for these, those who have sacrificed their life for the nation,
Your
at
lord.
least have some respect for them.
My lord, we are
We have never
respectfully
seen endless
submitting
people like this.
that, my lord, this land is not being in fact purposely used for
What
that
does
purpose
this
also, my lord.
cost? The High Court has dealt with the right of the High Court has dealt with the petitioner lightly by merely not by merely dismissing the writ petition. A person who has no respect for the
Your lordship, may I humbly submit, my lord.
war heroes who made supreme sacrifice for the protection of the borders of this country, Commerce should not have been allowed even to entertain, should not have been allowed to enter the High Court premises. And in any case, he should have been burdened with exemplary posts. We issue show cause notice to him, let him come and explain. And we'll hold an inquiry at whose instance is filing this petition.
My lord, may I humbly submit, my lord. His grievance is that that war memorial is also not being, my lord, properly constructed there, my lord. It's being, my lord, illegally, my lord, misused, my lord. See my pleadings, my lord.
This is all mischievously designed writ petition.
My lord, petitioner is, my lord, a practicing advocate there in, my lord, Dehradun. My lord, may see the pleadings, my lord. He is saying that
you want us to, how much cost do you want us?
My lord, with great respect, my lord. I want, my lord, this is SLP, my lord, this order, my lord. The legal provisions of section 2 was not considered. That's why, my lord, we have filed this, my lord.
Somebody who has vulture's eye on this land and somebody who are land grabbers sitting there, or he must be one of them, or his close relative, some family members must be there. That's how this all evil designed petition. Whereas we don't understand this.
My lord, may plainly dismiss this as, my lord.
Shame on him that you have problem with construction of a war memorial. You tell us what do you want.
My lord, may dismiss it, my lord.
Dismiss, then will impose cost also.
My lord may not do that, my lord, because legal, my lord
has approached the court with dirty hands. A cost of rupees 1 lakh is imposed. You are directed to deposit the same with the.
My lord, with great respect, my lord may not do so. My lord my lord ask him to appear through BC. My lord, I will ask him. He is also an advocate, my lord. After hearing,
asking him to appear through BC.
My lord,
why should be provided in BC?
My lord, imposing cost may, my lord, be a legal question was there that whether section 2, my lord, can be in this manner, my lord, be.
Anyway, choice is yours. Will impose cost of rupees 1 lakh.
My lord may not. My lord may then permit you to withdraw.
No sooner we were dismissing the specially petition with exemplary posts. Common Land Council for the petition seeks and permitted to withdraw the same. This may withdraw.
Oblige, lordship.
Item 23, my lord. May it please this honorable court, I appear on behalf of the petitioners. My lord, your lordships have issued notice in 3 previous petitions challenging analogous provisions of this act. However, the emphasis of each of the petitions is slightly different from the other. So I thought, my lord, your lordship might like to issue notice in
We
this.
can hear all the matters together.
Yes, my lord, if your lordship can tag them.
Whatever is being raised, we can formulate another question when we.
Yes, my lord, it's a rather complicated act to begin with. The statute itself is new because it talks of data protection for the first time in the country.
Issue notice.
And
issue notice returnable on 23rd March, probably the date. 23rd.
You have the previous orders. These are the previous orders, my lord.
23rd March.
23rd March.
23rd March 26.
Each of them emphasize a different aspect of the act.
To be taken up along with petition number so and so. When we will formulate the question, just point out so that
we'll do it. My lord, if I may briefly just tell you, the one is journalistic exception. My lord, public interest has been deleted from the RTI Act and also from the Data Protection Act. So therefore, a journalist cannot access data which is in the public interest. My lord, we concede that we can't have personal data, journalists need not have personal data, but if it's in the public interest, for example, if you're writing about a public servant itself.
Ultimately, the interesting question that will have to be determined is what is public data and what is personal data?
Yes, my lord, that's a critical question. The Act doesn't clarify that. So therefore, my lord, it will require judicial interpretation. And there is no definition of what is information and what is personal.
One interesting point can be whether a data with respect to a person, so long as he holds a public office, can it be termed as personal data or it will be treated as private?
Look, we are also interested only in people in public office, certainly not private individuals who have the right to claim.
Madam, at the time of hearing, you will have to suggest when there will be different hypothetical situations.
Yes, my lord.
And then probably we will be able to have a better analysis.
Well, not only hypothetical, but we can take cases that have actually gone to court under the RTI Act, where either the information has been allowed or disallowed, because these will be analogous provisions. Lord, in the RTI Act, there was an exception saying you can ask for information which is in public interest. That has been deleted from the Data Protection Act. Actually, that's what's causing the trouble. Otherwise, there would be no other problem. Then, my lord, the second is that the state has a right to call for any information. Of course, there are certain categories in sovereignty of the country, but they're overbroad. For example, they can call for information which is related to public order. Now, public order, as we all know, is a very broad category, my lord. It can include
but also,
anything.
Madam Indra, will request you to also suggest the measures to protect the individuals also. In a given case, if there are sweeping provisions permitting to have the complete information, and where the right to privacy and this conflict comes, then how to protect some individuals also?
Yes, well, the balance between the two, the balance between a person's private life.
So what can be the measures which can be taken without affecting the right to have this information?
Oh, now, especially now, my lord, we have a right to privacy in this country. So that right also has to be protected.
That balancing, exactly.
Yes.
That is what you...
Between the right to privacy and the right to public information.
Precisely.
Yes, but this act does raise all those issues.
None of the right should compromise with the other, and none of the right should become an impediment in the effectivity of the right.
The doctrine of proportionality, overbroad, all those issues will arise for consideration by the court. And my lord, last but not the least, the state exempts itself from the provisions of this act. So therefore, we'll have to see that they can collect any data about us. There is a certain fear of surveillance also, which emerges from the reading of the provisions of this act, my lord. So we are hoping that this honorable court will give some direction, some enlightenment on these issues, my lord. These will be the 4 issues, my lord. Whether there is a danger of surveillance, whether the state can exempt itself, whether journalists can write about it.
One is the state collecting data, and there is another matter before us. We hope that it will proceed and eventually will decide on merits, where our entire data of the citizenry, not only of one nation, maybe a substantial part of the globe.
It's a global issue.
Global issue going into the very big private entities. And
yes, well, the question of data sovereignty arises.
Data becoming the real true wealth as on date.
Yes, there are provisions in this act, my lord, which enable them to access data from other countries also. So data sovereignty issues also arise. Lord, we are just hoping that this court will give us some guidance on all these issues.
It's a very interesting point, and we would like to, in any case, not only interesting, it's a very eminently required and an issue which deserves to be prioritized and determined.
Yes, my lord, your lordship will have to look at actually all the provisions of the act. My lord, one more issue. Earlier, under the IT Act, we had a right to get compensation if our data was illegally accessed. Now they've deleted that right to compensation if data is illegally accessed, and they've said the compensation, if any, will go to the state. It will go to the board. It will go to the data protection
instead
board.
of the victim.
Yes, so that also will have to be. And my lord, one more thing, just for your lordship's information, the independence of the board. There is no judicial no judicial oversight into how the data protection board is constituted. My lord, your lordships have given judgments in Roger Matthew, etc., where there is a judicial oversight in how these quasi-judicial bodies are constituted. That issue is also there. Lord, I'll be happy to just frame a few questions and share them.
A tribunal which is meant to determine rights of the people is bound to be a quasi-judicial forum.
These are the 5 issues, my lord. I can do the questions and submit it for your consideration.
Yes,
Deeply obliged.
These are complete, will formulate all.
We'll do. Obliged.
May it please you, my lords. Whereas I am appearing for family members who want to give a decent quietus to the ashes. Now just note 4 things, Willis. I am the grandnephew. I lived with the daughter. The daughter happens to be on the screen now, Willis. Please now. Supports this petition.
Many times this issue will come to.
This is not that issue. That's the point it pains to make. No, Manoj, this is not that issue.
Indirectly, directly.
No, Manoj, no.
Timing also we understand everything, that why this petition is again coming after last year only we dismissed 2 petitions.
So therefore let me disabuse that. Your lordship.
First of all, where are the ashes, please? What is that proof? First of all,
yes, therefore, just let me answer my lord's query.
Where the entire family saying that we are united on this.
So let me answer that. Number 1, the sole heir is the daughter who's alive at 84 now. She's on the screen now. Number 2, the family says this, turn to page 37. The matter the lordship is hearing is to declare that he never died or he died. That's not the issue.
So that was the alternate prayer always.
That's inferential. Until and unless he dies, there cannot be a question of ashes.
The fact that every head of state from India, prime ministers have paid obeisance there at Renkoji temple is recorded. So let me answer my lord's query. My lord has raised the query, let me answer. To go sequence wise, come to 37. First, my lord's query about family members.
First, we would like to know that how many family members, surviving members are there.
Yes.
One of the greatest leader of this nation, no doubt about it. So none of us bow before
so let me
him and
answer one by one.
Supreme sacrifice.
Exactly.
But we would like to know that how many family members are surviving.
Netaji has 1 child only. Sole first class heir is Miss Anita Paff, lives in Austria. I made sure that she's on the screen now. Answer number 1. She's sole. Number 2, please come to 37. Let me place
before us.
She's
not the petitioner.
Well, the petitioner is the grandnephew who lived with them.
Let the heir come before us.
No, Manas. Therefore,
no, Dr. Singh.
The heir supports.
The heir supports. It cannot be a fight behind the clouds.
No, therefore,
if the heir wants the ashes or what the remains of this great hero
in fairness
we brought to our country,
yes,
the heir must come.
I hear, my lords. I expected their question in fairness. So give me 2 minutes now. Your lordship has raised many questions. Come to 37. If I can answer, otherwise I'll make sure that she files something. Just turn to 37. Come to 37. This is the daughter who's on the screen now at page 37. Just turn to page 37 once. She's writing
Dr. Singh,
in 25 and 26 now. Official statements.
We made it very clear to you, we respect her sentiments and we would ensure that her sentiments are translated into legal action. But she must step forward.
May I then do this, Willis? May I do this? Since I'm almost there with 1 millimeter difference, she's on the screen.
There are differences to our knowledge in the family itself.
Will my lords allow
with regard to the incidents which occurred?
So will my lords allow for 1 minute the lady to speak and I'll file the additional affidavit from her?
No. We actually raised hurry also in this petition. We know the timing also. Don't compel us to say so many things.
Well, there is no timing in this because she's been writing consistently.
Everybody
else has got mixed up in it. She has never said no. Then let me allow me to withdraw and come back, Balus, with the appropriate. Just allow me to withdraw. With the liberty. Your lordship is allowed me to withdraw with liberty. I'll make sure that she files an affidavit. Otherwise, my lord, the chief justice allowed me to withdraw with liberty.
All right, Judge then calls for the petitioner seeks and permitted to withdraw this petition. This will be.
May it please your lordships, the fundamental contradiction that I would like to bring to the notice of the bench here with my writ petition 285 of 2026 is RBI and government claims India booming economy, controlled inflation, raising per capita income, yet citizens cannot cope and necessitating interim PF withdrawals, treating retirement corpus like an ATM, and silver mortgages from April 1st it's going live, which is the last resort of the poor is allowed to be pledged. So I would like to bring it to the notice that if economy is truly rising, why distress-driven asset liquidation policies? So that's my primary concern, Your Lordship. What I notice is, a couple of points where, RBI itself shows the evidence of, exposes the fragility, basically, in economy here. Cash reserve ratio, sorry?
Where are you living?
I am put up here in Delhi right now. Put up here in Delhi as of now, but born and brought up in from Andhra Pradesh.
You are giving your complete address also of Andhra Pradesh.
Yeah.
What are you doing?
I used to serve software industry earlier, but right now I'm.
You are not doing anything.
Yeah.
So now you have started filing PAL. How many PALs you have filed?
This is my second PAL. This is my second PAL. Yeah.
What would be your first PAL?
Yeah, I'll speak about that also in a bit, Your Grace. Primarily, points that I would like to mention here is.
Later on, first PAL, let us. What happened to your first PAL?
Okay, that got dismissed. That got dismissed. I mean, I'm coming there. I mean, it comes as in the flow, Your Grace. So I would beg your pardon for that.
What is your qualification?
MTech in information security, and I served as software delivery manager.
So the person who is having MTech qualification, yes. Your annual income is how much you are disclosing?
Right now, I'm jobless and I do not have any income.
You are saying approximately rupees 1 lakh per annum.
I trade,
1 lakh rupees in a year.
Your Grace,
from where are you getting your?
That's what I'm saying. I'm trading, Your Grace.
So how many family members you have?
I do not have anyone.
You have family.
Yeah.
All right.
I'm all alone. I do not have anyone. I'm no dependents or anything. I'm all alone, and I trade, the stock market basically for my living, and I just make whatever is required. I'll just make it through my trading things. Right. The term cash reserve ratio, CRR, cash reserve ratio, says it's supposed to be address the part of reserve. That's basically the reserve. However, in last year, June, if we notice, cash reserve ratio was reduced to 3%. If we look at the history, ever since the RBI was established, the only time in the history you would notice CRR went down to 3% was during pandemic. 2019 pandemic, when the country was completely shut down, nobody was earning, no income was generated. At that point of time, using reserves makes complete sense. But when the economy is rising, economy is booming, you're claiming, you're making such claims, and in contrast, you're reducing CRR to 3%. In my previous petition, which got dismissed, this was my primary concern. I'll speak about why that got dismissed. I'll speak everything in the right now, Your Grace. So my primary concern was about cash reserve ratio reducing to 3%, while banks gamble, or they do business with 97% of their customer deposits. Right. For example, considering something like S-Bank scam. If say February 22nd, 23rd, it came to notice. I mean, it's in the news, basically, IDFC Haryana Chandigarh branch scam, where about 590 crores. That was very small amount. Considering IDFC Bank, who has got the customer deposits of 2.8 lakh crores, considering 3% CRR would be of.
With this? First, listen to the question. What is your problem with these schemes or?
No, I'm just raising the contradictions before I go to my case.
Why should we unnecessarily waste our time, judicial time, on an economic issue? Go and represent. Why have you not approached any authority?
Your Grace, I just want to. Okay, fine. I'll go directly.
The first petition, I think we didn't impose the cost only because knowing that you might necessarily.
Okay. Right.
Any problem with any? How do we understand? We are not the economists. We are not the subject experts. Go and tell the authorities if you have any problem.
I agree, Your Grace. I mean, in fact, this was the reason last time it got dismissed. Fine. So I raised RTIs with EPFO and Ministry of Employment and Labor for.
Is no reason to entertain this accordingly dismissed?
Your Grace, I pardon you, Your Grace. Let me. I beg your pardon.
3 of 2025, which was dismissed by this court on 7th October 2025, after observing that the matter pertains to the economic policy which fall within the domain of the executive. The petition was permitted to represent to the Union of India, comma if so advised. However, instead of submitting any such representation, comma at least nothing on record, comma, he has filed the second petition, which is nothing but abuse of process of law.
Your Grace, I would like to mention one statement here, please.
Not maintainable, with a word of caution that in case the petition found indulged in filing this kind of frivolous petitions in future, comma exemplary course shall be imposed.
Lordship, the challenge in this petition is to the constitution of the adjudicating authority created under the PMLA. Your Lordship, challenge here is to the constitution of the adjudicating authority created under the PMLA. The authority does not have a judicial member since 1st of September 2020. Lordship, similar petitions are pending.
You can tell the authority that your appeal should be decided only after some judicial member is appointed. That we are dealing with on administrative side, not in another PIL.
Your Lordship, there are similar petitions.
The non-member or judicial member is a good ruse for. I have nothing to do with my husband. Is as if you are living separately from the husband.
Lordship,
when you buy property from his asset, then your husband
Lordship,
is good.
the property is
When
purchased.
question of liability comes, then no, I'm an independent owner.
Your Lordship, the property purchased was in 2004. Your Lordship, the allegation pertains to the period of 2015 to 18. Your Lordship.
That on merits you can contest. We are not saying.
Your Lordship, there are similar petitions pending before this court. Your
Let
Lordship.
them remain pending. We will take care of those petitions also. Become paradise for dishonest people. So the issue with respect to appointment of judicial members as presiding officers of the adjudicating authority under PMLA shall be taken up separately in the PIL pending PIL reforms in tribunal. So far as the petition is concerned, OBC will be at liberty to pursue the matter before the authority concerned without prejudice to our rights, without prejudice to our plea that such pending proceedings should be decided by a judicial member. In the event of an adverse order, the petitioner shall be at liberty to agitate such plea before an appropriate court. With these observations, we see no reason to entertain this special petition, which is accordingly dismissed. Next, the OPC directive to list SLP civil number 12865 of 2018 for hearing after informing the counsel for the parties on 13th April 2026. Monday.
Your Lordship, in a similar petition in the high-tech matter, your Lordship has issued notice, Your Lordship. In a similar matter, Your Lordship.
We have listed that matter also. You are saying Not similar, you are only saying that the judgment which has been relied upon by the High Court, against that some SLP is pending.
Yes.
Ignore that judgment. Independently, the reason given by the High Court is correct.
Your Worship, in the meanwhile, the adjudicating authority may not.
Not from Union of India. Other findings.
Your Lordship, in similar matters on the same issue, coordinate benches have issued.
We list that also. We are listing that matter also, which we have pointed out. There is another one, we will list that also.
Your Lordship, in the interim, I may be, because the coordinate benches have granted protection, Your Lordship.
Tell us the number, we will list, and we are not inclined to grant any interim protection.
Your Lordship, the other matters which are similar matters are SLP Civil 5066 of 26.
You please give us the number, we will list all these.
Yes, we will, Your Lordship. Lordship, in the meanwhile, the adjudicating authority
listed along with case number so and so.
Your Lordship, in these matters, the protection granted is that the adjudicating authority may not proceed, but I will give an undertaking to the court that I will not alienate the property. I can give a similar undertaking.
That is only an interim arrangement, which we have said your plea survived. You go seek adjudication. Tomorrow adjudication is supposed in your favor. Are you going to challenge it on the ground that it by administrative member? You are not. Therefore, we have said this plea will not be taken to have been surrendered by you. Go and see. If the adjudication in your favor, what will happen? You will not say this order without jurisdiction.
Lordship, my apologies, but by the orders that we've seen so far, Lordship.
You have kept your issue alive as far as your ground is concerned.
Yes, Your Lordship. Your Lordship, this jurisdictional issue will not be decided by the authority itself, Your Lordship. That's the only concern. The authority today cannot decide if it has the jurisdiction to hear it or not. That's the concern that we have. That's why we've...
The issue of jurisdiction has been decided by the High Court. In the earlier judgment also, it is not the person, aggrieved person is before us. It is the Union of India on account of some observation that they are...
Yes, Your Lordship. That is the J. Sekar matter, Your Lordship. But in the other matters that I've just forwarded the orders, the accused...
It is not a quasi-judicial kind of where some independent rights are to be established. It's only a finding of fact.
Your Lordship, there are issues whether these are proceeds of crime or not. Those require judicial determination, Your Lordship.
That's why we listed that matter.
Your Lordship, in the meanwhile, I may be attacked and I may also be given the same protection that those parties have been given. Those are all affected parties that are here, Your Lordship. Those two orders that I have forwarded, Your Lordship.
Which orders are you pointing out?
Your Lordship, I'll just... Your Lordship, there is...
What is the date in the first matter?
Your Lordship, there is one order which is passed by Your Lordship, which is 16.
This is not the point where we remember this case. This is not the issue we are with.
Your Lordship, but Your Lordship may see Samrit Surekha, which is SLP Civil 5308 and SLP Civil 5066.
So in your case, the member is from the Indian Legal Service.
No, Your Lordship, he is not a legal services member, Your Lordship. He's a member from the financial services, Your Lordship.
He's not from the legal service.
No, Your Lordship. In fact, Your Lordship, it is an admitted position that since 1st of September 2020, there is no judicial member, no legal member in the adjudicating authority. Your Lordship, if Your Lordship sees SLP Civil 5308 and 5066.
This is not the issue involved in these matters.
Your Lordship, I'm carrying the High Court orders. This issue has been raised in these petitions, Your Lordship.
We remember because this matter was before our bench only. We remember the judgment also.
Yes, Your Lordship, that is the high-tech matter, Your Lordship. But the other two matters, Your Lordship, Samrit Surekha...
Other two matters, if someone has misquoted about high-tech matter, we can't really comment on that.
But in these matters, Your Lordship, the issue has been raised. I'm carrying the High Court judgment also to show to Your Lordship.
1169 is the matter which is before our bench.
Yes,
and that has been referred to, got tagged with those matters.
Yes.
What is the date in this matter, by the way?
Your Lordship, these are in May, Your Lordship. The date given, Your Lordship, is in May.
Your argument before the High Court was whether the quorum should be of 2 members.
Whether it should be of 2 members and also a judicial member, Your Lordship.
That argument is not there.
Your Lordship, it is a part of the petition. It is not recorded in the order, Your Lordship. Your Lordship, we may be tagged to the same batch. We may also be allowed to address the court on the issue.
That this issue has not been agitated before the High Court. We don't know what is the pleading. But at least in the oral submissions recorded, the fact that the separation of power doctrine is being infracted because of absence of a judicial member was never argued. The question was one of quorum as to whether it should be a two-member bench or a single-member bench can discharge the duties under section 6(2) and 6 because of subsection 5 of section 6.
Lordship, this is a ground raised in the petition, Your Lordship. I can show from the
That
petition.
is, there are 100 grounds are raised.
Your
But
Lordship,
whether
the
it was
Your Lordship, the matter was argued. While the judgment is detailed, the matter was argued for 5 minutes, Your Lordship, because based on the J. Sekhar judgment, it was the detailed order was passed late.
J. Sekhar does not go into this question.
Your Lordship,
J. Sekhar again dwells on quorum, whether it is a single member tribunal or multi-body tribunal. There, J. Sekhar holds that because of subsection 5 and subsection 7, it cannot be inferred that the tribunal must consist of more than one member. But what you are trying to tag is a different thing, that a tribunal must have a judicial member.
Your Lordship, both issues have been raised, Your Lordship, and in the J. Sekhar entire batch, there are several petitions from different states wherein both issues have been raised, Your Lordship. Your Lordship, the contention here is that if at all it's a single member tribunal, it should be a judicial member. So Lordship, therefore, my only request is that we may also be tagged to the batch, we may also be permitted to address the court on the issue.
The only issue ground taken by you is J. Sekhar judgment. J. Sekhar judgment, as far as agreed parties are concerned, private parties are concerned, they have not challenged. Union of India is before us.
It's the Union of India which has challenged, Your Lordship.
Therefore, how can you take advantage of that?
Your Lordship, I can show the relevant grounds, Your Lordship, where we have raised this issue before the Supreme Court also, Your Lordship. I'll just show the grounds from the petition, Your Lordship.
Union of India, that part of the judgment where this adjudicatory authority's composition has been upheld by division bench of the High Court. That part is not under challenge on behalf of the agreed person.
Yes, Your Lordship, but Your Lordship, with the J. Sekhar batch, there are several petitions which have come from different high courts. This issue has been raised, Your Lordship. It's a connected batch of several petitions.
There is no other petition except these two petitions which you are referring to. There somebody has cited pendency of SLP before our bench. In some other matter,
Your Lordship, that reference may not be correct because we checked the order passed by Your Lordship and the High Court order. It has nothing to do with the quorum issue, Your Lordship. We've checked that.
This is what exactly we are saying.
Yes, Your Lordship. We have checked that, Your Lordship.
You are very clearly telling us, but that's why we are pointing out that how these matters then raise this issue. I'm sorry to point out, someone said that the first bench has granted this order and pre-tagged.
Your Lordship, we checked the High Court judgment. It didn't deal with the quorum issue. But Your Lordship, my only request is that with the J. Sekhar batch, the other matters have been tagged.
How we find that your matter is the same issue? The only issue, similar issue is only in J. Sekhar's case. J. Sekhar case, private parties are not in
Your Lordship, in the batch, there are private parties which are before Your Lordship. In the J. Sekhar matter, there is a batch of matters where private parties are before Your Lordship. So therefore, we were requesting that we may also be permitted to be
at least now, are we clear that you don't rely upon this Simrit Surekha or Tushar Bansal's
order? I am relying on the Simrit Surekha matter because it's the same issue, not on the high-tech judgment. I will not rely on the high-tech order passed by Your Lordship because it does not.
Surekha has been tagged with that high-tech.
That, Your Lordship, my apologies, Your Lordship, but I will not be in a position to answer that question, Your Lordship. My apologies for that, but can't answer that question, Your Lordship.
Sure.
Whatever was argued was only on quorum. We actually searched because if the
in our matter, Your Lordship, we were heard for 3 minutes, Your Lordship, based on the J. Sekhar judgment. We were told that you have no locus to be here in view of the J. Sekhar judgment. The detailed order was passed later, Your Lordship. That's the only problem. Your Lordship, Your Lordship, the only request here, Your Lordship, the entire batch is pending here. Your Lordship may not give.
That you please tell me, we are showing that this, in this matter, there is a misleading statement.
Yes, Your Lordship. I will not say misleading because that's for Your Lordship to say, but,
You can say,
but Your Lordship, I will not rely on the high-tech order. I cannot rely on the high-tech order.
colleague, but this isn't it a misleading?
Lordship,
High-tech matter has nothing to do with it.
I'm not relying on the High Court order, Lordship. I'm relying only on the fact that the entire batch is pending before Your Lordship. So I may be tagged to the batch and be permitted to address Your Lordships on the issue when it is taken up. Your Lordship, if Your Lordship may see page 466 of the SLP, this is a part of my petition filed before the High Court, Your Lordship, which is ground J, Your Lordship. Your Lordship, there is a subheading J. It says composition of adjudicating authority suffering from the vice of quorum non judice. Your Lordship, for that the entire impugned proceedings and further Your Lordship may kindly see the paragraph A, Your Lordship. It says, for that the entire impugned proceedings are further rendered illegal and unconstitutional, being hit by the vice of quorum non judice, apparently a member as acting chairman who may not be from the field of law alone is conducting the proceedings within the nomenclature of adjudicating authority.
Entire argument essentially was not that he's not a member of the legal fraternity. It was whether it is to be by a two-member bench. And there even if you say J. Shekhar primarily is going on that proposal.
Your Lordship, what has been recorded in the impugned order here, Your Lordship, is entirely based on J. Shekhar and not the petition here. If Your Lordship sees this...
What is the point in Tushar Bansal?
Your Lordship, there is an issue of quorum non judice raised in that. I will just forward the High Court judgment, Your Lordship. We forwarded it.
No, but then how it has been got tagged with high-tech?
Your Lordship, my apologies, I'm not in the position to answer that question, Your Lordship, but they are not. The only commonality in the orders, Your Lordship, is section 5(1).
Now tell me at the earliest which Monday is available.
Which one?
On 13th April 2026, SLP civil number 5066/2026 and SLP civil number 5308 of 2026 be de-tagged from SLP Civil Diary number 66191 of 2025, comma, and B listed for hearing on credit DSP on 13th April 2026 along with this matter. Counsel for the parties may be informed in advance. Then say SLP Civil number 12865 stroke 2018 in bracket Union of India and other versus J. Sekhar SEKAR. We also listed on the same day.
Lordship, we are before the adjudicating authority tomorrow, Your Lordship. The adjudicating authority matters listed tomorrow for us, Your Lordship.
No, you tell them that we have adjourned this case. We are not granting any stay. Now that you yourself will agree that all these 2-3 persons are obtained by misleading the court.
Your Lordship, I will not say that again, but
on that,
yes, Your Lordship.
Please, at least we understand that you will not be able to say.
Most obliged, Lordship.
Now, please do. This is an anticipatory bail matter.
Earlier regular bail.
My lord,
He has been absconding too.
No, I was not absconding. I was But I was not absconding. I was regularly appearing before
That
the
matter,
IGO.
what Milords, as Annex 5 is referring, that
We have already granted bail.
Milords, that was against the cancellation of regular bail. Milords had then stayed that order, Milords. That is a separate thing. He is absconding, Milords, as per the status report filed by them also, Milords. He's asking for an anticipatory bail since the lodging of the FIR. He has not come and, Milords, he's not come before the investigating officer as well. This is the correct facts.
So was he earlier granted anticipatory bail?
No. The present petitioner, no. The present petitioner, no, Milords. Milord, may kindly have page 94. Milord will have clarity.
Case, Milord. He may not be right.
Lords, we just have page 93 and 94, the status report filed before the Honorable High Court by the State, Lords. Lords will have clarity on all the
place
accused
couple of facts, Milord, before my learned. Let me just place the facts.
Even High Court declined your bail.
Lord, High Court did not decline. High Court granted bail. And if my lords recollect, they said, I have given an undertaking to facilitate that his balance 1,94 lakhs would be made over to him. Therefore, if I couldn't do that, my bail was cancelled. I came here, my lords granted me 2 weeks to facilitate, and he got the entire money. And this order was
granted bail. That is not the issue.
No, this order was set aside. The impugned judgment was set aside by my lords on 23rd of February.
We are talking about the today's petitioner.
Yes, my lord. Now kindly have page 8, my lords. Court, my lords, dismisses my petition because the other person's bail was cancelled. Kindly see page 8, last paragraph. Since the main accused bail has been cancelled by a detailed order, the same detailed order, I find that case of petitioner would not be distinguishable. So my matter got dismissed only because his bail was cancelled.
Before dismissing on January 12,
pardon?
Were you, before dismissing your anticipatory bail petition on January 12, were you earlier granted?
No, my lords, I was not granted. My petition also came up, it was tagged along with this. But no, my lords, what has happened is because this matter, the person's bail was cancelled, my petition got dismissed. But now, my lords, have restored the original bail to that person. This order has been set aside. Page 8, bottom.
The FIR is of January 25. You have never been granted. Earlier person to whom we granted bail, he was released on bail. I could cancel his bail on the ground of non-deposit or non-payment of.
That has been deposited.
That issue was settled.
Correct.
We stayed first way order. We allowed you to continue on bail, and then we set aside the High Court order. As far as you are concerned, this FIR is of January 25.
Correct. Not because I was called for investigation. I was called for investigation. I was regularly appearing before him.
My Lord, I was summoned by the IO. Lord, I was summoned by the IO. I regularly appeared before him. That is why I was not arrested. Though my anticipatory bail was pending.
Claiming that he appeared before the IO.
My Lord, this statement I have annexed, my
Lord,
Lord.
8 September 25.
My Lord, with that respect, my Lord, it's mentioned in the status report. I will not dispute that aspect. But with respect to that, because the High Court, after reading the status report, that he is not cooperating. My Lord, I know what cooperating. My Lord, I will have to seek instructions on that aspect on 8/9/2025, that what had transpired and on what grounds the Honorable High Court dismisses, because he's not been coming forward. The challan has also been produced for other co-accused and the trial started. With respect to these two accused, my Lord, at page 94, 0.6 and 0.7.
You can verify now.
I'll verify that.
I can verify, my Lords. I have appeared continuously.
But this is a nexus, my Lords, which has been, my Lords, it's a 27 CR matter. It is not 5.
And the only allegation, my Lord, may I say, just the only allegation is the main accused has sent a transferred amount of 1 lakh to my account. That's the only allegation against
me. Issue notice then Mr. Vivek General. AG for the state of Punjab accept notice. In view of the specific government to the fact that the petitioner had earlier joined the investigation, committee directed that his arrest shall remain subject to joining the investigation, subject to further joining the investigation as and when required. Then State Council will find out whether the petitioner had earlier joined the investigation or not. Post consular.
Lord, can it be next Friday, my Lords? My only allegation is 1 lakh, my Lord, against me. The only allegation is 1 lakh, my Lord, from main accused to my account. The only allegation is from main accused, 1 lakh has been transferred to my account. That's the only allegation, nothing against me. He makes the entire village an accused.
Today, we have let us verify.
My Lords. Lords, may I list it next Friday, my Lord, if possible, if not inconvenient, my Lords.
We'll see.
Okay.
My Lords, having seen this, I have spoken to them. I have also seen your Lordship's order dated 21st January.
A review petition, basically.
Lords, I pointed out the same thing to them. Lords, may I only say?
It's that one story of exercise. You assist the court when these matters are taken up.
Lordships are right. Lordships are right. Lordships have said we will not entertain any objections. We told them the same thing, Lord.
That is what also. To this so-called PIL is made of this one.
Lords, can we withdraw to file an intervention in MC Mehta if required?
No intervention. We will not allow to intervene. He is
only to remain. Yes,
lengthy services to someone.
Lordships are right.
They are not a PIL. It's there is some big involved behind it.
No,
it's not a routine PIL.
To check the credentials as much as I could, Lords. I told them we will be asked to go to Ludhiana again. So please, we are in Rohini, Lords. I was only saying this.
This is at the instance of some toll plaza contractor,
Lords,
who has, if not financed, he has heavily let's not say anything.
Lord, PIL credentials should be checked.
Because once we pass this order, they know it.
Yes, so I spoke to him, Lord. Their only concern was that other measures may also be taken. Additionally, if CAQM can just consider our representation.
No question of withdrawal. Tomorrow, he will create, start blackmailing them.
Great rule. Deeply appraised.
Yes, for petitioner, my Lord, the arguing counsel is not well, my Lord. I seek some accommodation. Arguing counsel is not well. Lord, I seek some accommodation, my Lord. I seek apology also for not, my Lord, circulating the letter in time. Lord, it was not accepted, my Lord. It was 11:30. Matter was argued before court hall number 2, and my Lord, thereafter, since your Lordship was pleased to, my Lord, pass orders on the previous round.
See, how many years this different rounds of litigation will continue?
I request, my Lord, some accommodation.
Counsel for the petitioner letter seek some granted. Seeks an adjournment, post the matter on so today.
Please.
Item.
Well, the letter was moved by the petitioners.
There is no letter, but thank you very much.
27.
My lords, in item 26 is Malas connected with 25.
26 has gone, sir. We are talking of 27.
Please, my lords, I appear on behalf of the petitioner in 27, my lords. Mr. Mehta is leading me, my lords. He is not keeping well. My lords may
we
accommodate, my lords. Mr. Hegde, I believe, was informed.
Sliver of hope.
Please, my lord.
There seems to be some sliver of hope, Mullah, so they want to be
Last
saying anything.
he has not.
No, we can't possibly object, Mullah. He's not well. How can we object?
Total this.
your lordships will
Tushar Mehta and Solicitor is deputy to be unwell. On request, post the matter for full consideration on so and so date.
on my lords that
Will notify it.
immediately in April, my lords, that after that Good Friday thing. That's the only request I can make. I can't.
We'll try to accommodate the protest.
Deeply obliged.
Because we have given every material and it's been there so long.
This is also another exercise I have to undertake in the evening to find out the dates and adjust the matter.
That's the most difficult one, Mullah, I guess.
My lords, these are families, poor families, which got picked up wrongly maybe.
That's
but
why we are saying find out the
as
shorter
early as possible.
Longer slot is no difficulty. Shorter slot we'll find out.
Grateful, my lords. I'm grateful.
Deeply grateful. We have the petition in this matter. May I just pass on? There are 3-4 dates which are relevant. May I just pass on a short list of dates? I'll not trouble your lordships with everything. There is a preliminary. Just pass it on. There is a.
Yes, please.
I've just passed on 3-4 dates I wanted to point out. Lordships, I'll not trouble your lordships with the rest of it. Please have 16/12/2006. A preliminary notification is issued under the Karnataka Industrial Areas Development Act in respect of 918 acres, 1 gunta situated in so and so. Thereafter, my lords would have 28/8/2020. I'm sorry. Thereafter, your lordships would have 9/4/2008.
Stop rules.
Yes.
The very first item is that 6 acres, 16 guntas.
Yes, so your lordship, I didn't want to bother your lordships with those details. The relevant dates I just wanted to point out. 16/12/2006 is the date at the bottom of the page.
No. We are only asking, is the petitioner society owner or?
It's the owner. It is the owner. It is the owner.
Don't mention it in the note.
I'm so sorry. It is the owner. I have mentioned the owner of the lands on 17/2/2004. It has become. It's next date I mentioned. While registered sale deeds dated 17/2/2004 and 26/6/2004.
All right.
It's operating an orphanage over there. Bottom of the page, 16/12/2006, R3 state issued preliminary notification under section 28(1) of the KIAD Act, that's the Karnataka Industrial Areas Development Act, in respect of area measuring 918 acres, 1 gunta, situated in Bagalur. Lordships may ignore the rest of it. 9/4/2008. Respondent 3 state issued final notification under section 28(4) of the KIAD Act in respect of an area measuring 869 acres, 9 guntas. This was challenged, my lords, by the petitioners before the Honorable High Court, and by a judgment of 17/6/2010. The learned single judge quashes the notification, saying that I have not been heard, but permits the board to carry on from the 28(2) stage, that is to hear me. 28(3) is, my lords, like section 5, your lordships is aware, I am to be heard, and then the final notification is passed under 28(4) under the KIAD Act. So the single judge quashes the notification on 17/6/2010 and permits the board to carry on further under 28(2). So
Thereafter, my lords, after 17/6/2010, on 11/10/2010, in compliance of the order dated 17/6/2010, notice was issued to the petitioner to attend the re-enquiry on 11/10/2010. 23/10/2010, enquiry under section 28(3) was held on several dates from 23/10/2010 till final enquiry on 2/5/2016. Then your lordships will see the next date is 2/5/2016. So there is a gap, my lords, of about 6 years after the 28(3) hearing. 2/5/2016, R2 Special Land Acquisition Officer passed an order dated 2/5/2016 under section 28(3) of the KIAD Act, rejecting objections raised by the petitioner and ordered that lands in question be acquired by issuing a final notification under section 28(4) of the KIAD Act. 6/2/2017, the petitioner submits a representation on 6/2/2017 requesting KIADB to give up the lands in question from the acquisition. Then your lordships will see 2 years later, 9/5/2019. So this is, my lords, almost after the 28(3) hearing started. It is about 9 years thereafter. In view of the above mentioned representation dated 6/2/2017, more than 2 years later, the Special Deputy Commissioner KIADB issued a communication dated 9/5/2019 to SLAO to consider whether the lands in question are absolutely required for industrial area and, if needed, to submit a proposal for final notification immediately. By the same communication, it was stated inter alia that it does not appear that the proposal for issuance of final notification under section 28(4) of the lands in question has been submitted to the government. Then 7/8/2019. Even after 3 years and 3 months since the order dated 2/5/2016 under section 28(3) of the KIAD Act, 9 years 2 months after the passing of the order dated 17/6/2010 in WP number so and so, and 12 years 8 months since issuance of the preliminary notification dated 16/12/2006 under section 28(1) KIAD Act, admittedly no final notification under section 28(4) came to be passed. The petitioner therefore filed writ petition number so and so before the learned single judge. And at page 6970, it was prayed inter alia that the acquisition proceedings initiated by preliminary notification dated 16/12/2006 be quashed insofar as it relates to the lands in question and be declared to have lapsed. 12/2/2020, the learned single judge allowed the writ petition number 34032 of 19 and quashed the proceedings, which is preliminary notification dated 16/12/2006 and order under section 28(3) dated 2/5/2016 as abandoned and lapsed. The reasons, my lords, I'll just briefly state. I'll take your lordship through the judgment, but 2 years should be a reasonable period within which final declaration should be made, and if not made within a reasonable period, the preliminary notification and the acquisition proceedings are required to be quashed. Applying the aforesaid law and observations, that preliminary notification was issued on 16/12/2006 and order under section 28(3) was issued on 2/5/2016, and since no declaration has been issued hitherto, learned single judge quashed the acquisition proceedings. 28/8/2020. Against the judgment dated 12/2/2020, respondent 1 KADB and R2 SLAO filed an appeal bearing writ appeal number so and so before the learned division bench. It was contended in the writ appeal that a proposal has been sent to the government for issuance of final notification which was yet to be issued. The learned division bench stays the order of the learned single judge. Then 4/11/2021 is when, during the pendency of the writ appeal, after the single judge had quashed, the learned single judge's order was stayed. And therefore, on 4/11/2021, during the pendency of the writ appeal number 604 of 2002, I'm sorry, it should be 2020, R3 State issued a final notification under section 28(4) of the KID Act. Note, final notification has been issued around 14 years, 11 months after preliminary notification dated 16/12/2006, around 11 years, 5 months after the order dated 17/6/2010, and around 5 years and 6 months after the order dated 2/5/2016 under section 28(3). 35/2022, the learned division bench, my lords, has set aside the order. The reasons for setting aside, I'll just point out. The learned division bench says that and rightly so, that the timelines prescribed under the old Land Acquisition Act do not apply to the Industrial Areas Development Act. On that, I can have no quarrel. Your lordships have decided that. The learned division bench then agrees with me that even if there is no timeline, that should be issued within a reasonable period of time. But says that in the 28-3 proceedings, I had taken time on some occasions. Therefore, I can't complain of a delay. On that, my submission is even after the 28-3 order is passed, even then substantial amount of time has elapsed. And B, it says, the learned division bench says that I have not challenged the 28-3 order. Well, 28-3 order is like a section 5 order. My objections are rejected, but the final notification has to be issued. And thirdly, the learned division bench says that I have waited for a long time after the 28-3 order to approach the High Court. Lapsing would happen only if I wait. If I approach the court immediately, my lords, it would not. Now, on these facts, my lords, my respectful submission is, first, the question as to whether in the absence of a timeline prescribed under the KIAD Act, whether the final notification still has to be issued within a reasonable time, I would show, my lords, 2 judgments to your lordships. And secondly, my lords, my submission would be that I cannot be held at fault for this kind of a gross delay. It is not, my lords, a short delay. After the learned single judge had given them an opportunity to redo the entire process. That, my lords, was in 2010. Thereafter, it is about 11 years. And during the pendency of the writ appeal, the final notification is issued. May I, my lords, show to your lordships the documents themselves, the impugned judgments itself. First, kindly have the judgment of the learned single judge at page 71 to 77. And the reasoning, my lords, at page 76, para 9. Having heard, my lords.
Which judgment?
I'm sorry. Learned single judge's judgment I was reading, which had decided in my favor. Then I'll take your lordships through the learned division bench's judgment. It starts at page 71, reasoning at 76. My lords, have. Having heard, may I read that, my lords, para 9. Having heard the learned counsels for the petitioner as well as the respondents, this court finds that the issue is no more res integra, that for issuance of a declaration under section 28.4, though no time period has been fixed in the statute, however, it has been consistently held by this court and the division benches that a period of 2 years should be the reasonable period within which a final declaration should be made. And if such a declaration is not made within a reasonable period, the preliminary notification and all other proceedings of acquisition are required to be quashed. Now, my lords, please see the manner in which the impugned judgment deals with this issue, these issues. Please first have page 13.
Where is 28.4?
28.4 is, my lords, please have my appendix at page 41. (28.4) is something like section 6 of the old act without any timeline being prescribed. May I take your lordships through the entire section 28 for you?
Neither the division bench nor the High Court dispute the fact that a 28.4 must come within reasonable
That's
time.
right. That's right.
But the single bench puts a legislative intent.
I am not on 2 years.
May be inspired by 11.
Perhaps it appears so.
Inspired by 11,
appears so, but
which perhaps is not correct.
I would not because
Both are very poor judgments. Statement by the division bench that any time can be issued. Are you sitting in a king chair that you can take 20 years, 10 years, 15 years and blaming them for the delay? If somebody is not coming, your officers are helpless. What prevented you from passing the issue the final notification?
I had given a representation, in fact, at a certain stage.
They are simply asking you to release the land. You don't want to release. Don't release it. Issue the notification.
Your Lordships may kindly see in this case, so far as the notification
Now,
is.
please explain what is it. Let's sit down.
Great.
Absolutely honored.
But so far as section 28, 1 to 28, 6 are concerned, your Lordships will find 28, 1 is equivalent to section 4 and 28, 4 is equivalent to
And
section 6.
please first show cause why we should not strike down this provision. Under the Land Acquisition Act, Central Act, there is a mandatory provision.
Please.
Your state enact a law and you say without any fixing time you can issue. You first satisfy the test of Article 14.
I'll just point out, your Lordship, I'll just, because this issue has not come for the first time, earlier also your Lordships have considered it, my Lord.
We will see more judgments also.
Judgments, my Lord.
Please show us state judgment saying that you have indefinite period at your sweet will. Your babus can sit like Maharaja and take years together to issue the final notification.
Right.
Show us that judgment.
Indefinite period, but they say that 2 years period, which has been stated in that so and so, that may not ipso facto.
After the reasonable period, following the legislative intentment from the 1894 Act, Section 11.
Please, Master.
Right? Then how many years have you taken here?
No, I'll just point.
13 years.
No, my Lord, your Lordships may kindly see in this case what has happened. Initially, it was struck down and the matter was sent back, my Lord, so that because my learned friend's client is not a recorded owner, my Lord. Therefore, initial stages he was not. I'll just point out, my Lord.
For all acquisitions where the delay is more than 2 years. That's the only way to deal with the bureaucrats.
I'll just make my submission on that. Your Lordships may kindly permit me. My learned friend's client was not a recorded owner at that point of time, and he has admits it in his returns in his writ petition, my Lord. Now, once he was not a recorded owner, notice was not given to him. Thereafter, my Lord, he filed a writ petition, and writ petition we were asked to do it from the stage of 28-2. That SLU has conducted the inquiry. In that inquiry, your Lordships will find his objections have been rejected in 2016, my Lord. And the final notification has been issued in 2021, my Lord. To that extent, I agree with that. But your Lordships may kindly see, so far as learned single judge is concerned, Lord.
Madam, is it not an unreasonable delay?
How can you justify for 13 years, madam?
No, it's not 13 years, my Lord. It's actually total from 2016.
Like any other argument.
My Lord, I need to produce, show some couple of judgments on that, my Lord. Because your Lordships have in Gannar and in trading and all.
We'll give 5 minutes after lunch.
Please, boss.
May I just make a request, Lord? May I with your Lordship's permission make a request? Lord, there's item 49. There was little urgency in this matter. Lord, this is that case on interpretation of organized crime. My Lords had been pleased to say that that judgment would not act as a precedent. Now, what is happening is others have come relying on the judgment under challenge in the same case and seeking bail on default bail, though your Lordship is examining that issue. That's my challenge.
That appealing for impleading
item?
Lord, item 49, my Lord.
Item 49 is far away.
I'm sorry, Lord?
Item 49, the turn is yet to come.
Lord, I know, but that's my concern. Because, Lord, I'm asking for a stay.
We have some very other important matters.
I know, Lord, this is an issue where not the state is seeking, Lord, stay, Lord, because what has happened is
First of all, there are some other matters.
All right, I'll wait. I'll take my chance.
Yes, madam.
Please. Just, I know my difficulty. 5 years, my lord, from 2016 also, it's 5 years. I know but your lordships may kindly consider two aspects. Firstly, my lord, so far as 28(1) is concerned, my lord, up to 28(4), the moment 28(4) notification is issued, the land vests with the state government under 28(5), my lords, because it is unlike Land Acquisition Act. Now, my lord,
Without payment of compensation, without doing anything.
that's it. Now, your lordships may kindly see in this case what has happened is that now notification, final notification has been issued. But it can be, we can always issue the fresh notification as your lordships have already said. But my respectful submission is if the date can be considered same as for final notification, my lords. If your lordships may kindly see, my lord, our project, my lord, I have produced the additional documents, my lord. For entire project, your lordships can see it at page 5, my lords. It's consisting of about
That they are not running an orphanage there.
they are running. Not running a corporation. No, my lord, we are not disputing. We have not disputed it.
If you are not disputing that, what the heaven will fall if one industrial plot is not sold?
My lord, your lordships may kindly see I have produced the sketch, my lord, what we have done. Part of the road goes in that land, my lord. We have just, your lordships may kindly have a look at this app, my lord.
To the extent you require, say, for regulative development, say, for example, part of a small strip of land might be required for construction of road, for laying of sewage or water supply or anything. To that extent, you can acquire rest of the land where they are running an orphanage. Who comes forward today now in the current day society?
This is
look after these children. God has not been very kind to them. 189 children they were there at that time. Might have been increased or decreased.
But your lordships may kindly consider, my lord, so far as this particular land is concerned.
It's not that. This is only a factor which is waving in mind. The reason we will give as per law only. It's not that we will mention the reason. But our reason will create problem for you.
But so far as
your other acquisition might be affected.
So far as what they are running, my lord, I cannot say at the moment because your lordships may kindly see so far as our acquisition is concerned, my lord. In case your lordships may kindly see my application for additional document, I have produced the maps, my lord. In that I have shown the position of this land. And my lord, almost about 4,000 acres.
This acquisition is purely simply for profiteering. You are an industrial development corporation. You are carving out. You have carved out industrial plots.
Please,
whether you allot, if you will allot through some other mode, obviously you will do to favor someone, high affluent people. If you will go for auction, you will fetch money, you will make money. It's only pure profiteering. On one hand, the other, the side, the parties, they are running a orphanage there. 6 acre, maybe that half acre, something you require for development purposes. You can take that bus land.
No, that, my lord, I can see construction so far as that part is concerned, but in case your lordships may kindly see the location.
Arguments, whatever you have, we have understood your argument. That 21(4) does not have any time limit, and therefore only you can do it within a reasonable period. Second argument is reasonable period. It is there because they have been approaching different authorities, and therefore you were in a kind of a uncertain situation and couldn't take the final decision.
No, but so far as up to 2016 is concerned, there is no difficulty because we already explained 28(3) proceedings were pending, and as on that day, the order has been passed on the 28(3) in 2016. No, therefore, up to 2016, your lordships may kindly consider because that is at his instance, because he was not the recording order. The matter we had to be heard thereafter.
All right, arguments heard, order.
Only two, in case your lordships may kindly see two judgments,
why not? Why not? 2, 3, 4, whatever. Duty bound.
My location, in case your lordships may kindly see, my lord, location I have produced along with my application.
Arguments heard, order reserved.
May I see some judgments? Two judgment, because one is
Yes.
prior to the timelines in the Land Acquisition Act also.
May I say something on behalf of the state? Since this is an orphanage, that is the matter is such. On behalf of the state, since this is an orphanage, and in case this land, only because a small part has to go in road. The acquisition proceedings started in 2004, and in 2006. They purchased the land only in 2004. So the orphanage must have been
That we have said.
after.
Had it been a case of purchasing the land after process had begun,
That
we would have thrown them out in a second.
Subsequent purchase, your lordship's judgment is very clear on that.
Says it that 2 years before you commence the acquisition.
Instead of lordships passing a judgment, may I just say, I'll take instructions from the state, in case this land is not, can be let off from that development area, it may not be required. Lordships may give us an opportunity. I'll take instructions.
We are giving you time. We are not delivering a judgment. That's why, in fact, I had planned to dictate it just now.
Please,
and normally I do that. We would have dictated the judgment. We have made up our mind. Whatever tentative we thought, subject you will argue.
Please.
But we are deferring the delivery of judgment to enable you. But we are not mentioning. We don't need any assistance in that regard. If you yourself take a decision, please inform us. We are granting you week 10 days time.
That's fair. If your lordships for my satisfaction, just have the plan that has been affixed by them in the additional documents. Basically, there are two plots. One plot, the road is not going through. There is one plot through which the road is going.
These plots are what you have carved out on a piece of paper. Their
land. I'm saying they own two pieces of land. On one piece of land, the road is not going through. On the other, through the other piece of land, the road is going through of the entire layout.
Let these unfortunate children also have some space to play, to walk, to sit outside.
I am not saying that. I am saying that only till the extent that the road, only confining to the extent of the road. Because
whosoever is your prospective allotee, whom you want to oblige, you oblige him somewhere else.
Even if there has to be cancellation with regards to the allotment, because these are this is an orphanage and they are underprivileged. We'll take that decision. We'll take that decision. May just give us a week, 10 days time. We'll place it at the highest level.
Not difficult. We are granting you time.
Please, we'll do that. May only allow us to so that the road can pass through. Otherwise, most of it is anyway protected.
Once you take a decision,
we'll inform.
You can bring a revised plan,
please,
ensuring that substantial part of the land remains with them, along with all facilities, open space and everything. If you need a part of a small piece of land, and for that you will pay compensation,
of course,
as per the rate in 2021.
2021.
As per the new law.
Please, Lordships may just give us some time. So we'll do it.
We'll do that.
Grateful. Great.
Item 32. Mother Sultan.
Lordship, this is an IA on behalf of Madras High Court.
Who is representing Allahabad High Court?
Please, my lords. In that case, your lordships are indicating any date, my lords? In the real matter, your lordships are indicating any date, my lords?
No, order reserved. Arguments heard, order reserved.
Just
announce it. Because if
we will not pronounce the judgment, we will eagerly wait for you.
Just
to come with some.
On the judgments, which I guess, should I give paragraph numbers of that?
You must have mentioned para number.
To me, the authorities would say that their lordships have already reserved judgment. I will be able to communicate better, if your lordships may just put it on another date, we will not argue. May just put a date after 10 days.
We can only say arguments heard, order reserved, post on so and so date for orders, for pronouncement of
it. May say that. May say that. Because if your lordships will say reserved, it will be very difficult for us to take decision. That is the only thing.
It's 32. Yeah, you're fine.
That's
That will be
No,
unfair.
Malas, otherwise they will say that they have
You heard
reserved
that.
judgment. You are asking us to do this, Malas. I'll communicate it to the best of my ability.
You don't have to say that, sir. You don't. We will deliver the judgment. Then you can take your call.
No, Malas, I'll take the call Malas, we'll take the call in the shortest possible.
Then we are granting you at least 2 weeks time. Your arguments are post on so and so date for orders. That's all.
Lordships may add one line. In the meanwhile, the state may take instructions as Malas did say that. Malas, that will enable me to take instructions.
Arguments are, however, we defer the pronouncement of order as learned state counsel as well as learned senior counsel for so and so corporation. Want some time to have test instructions. That's it. Post on so and so date for orders.
Grateful.
Request your lordship one thing. Whereas I have filed interim application, I am representing.
Item 32, sir. Item 32.
Yes, item 32. Whereas I have filed.
Who is for Allahabad?
My lords.
But my IA is for implement.
Take the mic.
Milords, my IA is regarding a implement application along with an application seeking direction. It is for UPHJ.
You are the applicant, Dinesh Kumar Bansal.
Yes.
Where is the question of, tell us, madam, where is the question of waiting list? How much posts were advertised?
Milords,
200.
In 2018, I am here in the recruitment process for 2018.
You are asking for 2 reliefs. One is that a waiting list should have been published.
Yes, Milord.
Right?
Yes.
How many posts were advertised?
How many posts? In the original vacancy.
Original advertisement.
So, Milord, in the original vacancy.
अब देखो आपने होमवर्क नहीं करेंगे तो कैसे लोग क्या करेंगे फिर?
I just got to know about this matter. I apologize, Milord.
200 plus posts were advertised.
Yeah, 323 was there. 323.
Almost 320.
Yes.
How many officers were? How many candidates were selected?
Out of so what I have here is that 114 vacancies were to be filled in HJs and 112 were filled. And after that, 15 or more vacancies were there.
Therefore, the question of waiting list comes only when all the posts, total advertised posts, a main selection list is prepared, and there might be some anticipated vacancies for which you prepare a waiting list, or maybe that the candidates in the main selection list don't join, and therefore to replace them, you prepare a waiting list. Here is a case where the posts advertised are much more than the selected candidates, because there were no suitable candidates available. So where is the question of waiting list?
Milord, so here what has happened is that after the judgment in the case of Dheeraj Moore, 15 vacancies were 15 posts, 15 candidates who are already.
No, you can't ask for preparing a waiting list in a case where the total selection list is far less than the advertised post. Waiting list comes only when all the selection list completely exhausts the advertised vacancy. Eligibility
must be eligibility.
Well, did you say? And 43963, we have heard and counsel for the applicant. No case to issue with the guide direction made out. Both the applications are accordingly dismissed. Now comes Madras. Who is representing Madras High Court?
I'm representing Madras.
What kind of selection are you making?
From 2019.
You don't select in Tamil Nadu, you don't have a eligible, suitable lawyer available.
No, 2019 we did it for twice, Your Lordship. Thereafter 2022, 2023.
You produce your record of interviews.
No.
We do not know how the High Court is dealing with the lawyer.
Lordship,
how many times posts have been advertised?
Please, 31 in 2019. Lordship, 2019.
How much interview do you give in the Viva interview marks? 5%, 6%, 7%.
Lordship, when it was called in 2024, whoever came to Viva, we took everyone inside.
31. Well, this is absolutely done at the instance of the junior division level officer because they want to promote all the vacancies.
Please, my lords.
No, Lordship,
Please, my
no,
lords.
Lordship may not say. Lordship may kindly
This
consider.
is your interview record. We would like to see who are the judges and how are you interviewing the candidates.
2019, we did it twice, Your Lordship.
First, the lawyers are not available. Good lawyers are they don't join the services. And if somebody has qualified the written exam, this is how you are behaving with them. Yeah, I could right on.
Please, my lords, in this same
Direct you to produce the original records regarding interview of the candidates who qualified for direct recruitment, of the candidates, namely the members of the bar who qualified for VIPUL. So no other application in this matter.
Please, my lords, there are two other applications which has been put by me, my lords. That is IA 232-969 and 232-968, my lords. This is pertaining to
Rajas.
Please, my lords.
You are for Rajas.
Please, my lords.
One of the aggrieved advocate is poor fellow here.
Please.
He says you don't hold the exam.
My lords, I'm here. My lords,
Lordship,
my lords, I'm here.
He's an aspirant at
He's an no, he did give exams, my lords, but then the results, my lord, I'm just wanting now for the compliance of Malik Mazhar, my lords. Every year there should be, my lords. There's a time bomb. But then 2013, 2018, 2019, my lords. But thereafter it does not take place, my lords.
No.
Despite there are vacancies even as of date, my lords.
Meanwhile, the High Court is directed.
Let it be taken out by 31st March, my lords.
Now that you need a direction, then we'll
say
do
this,
that.
Lordship. 2019, we had did it twice.
Meanwhile, the High Court
2020,
is directed to
2020.
issue advertisement for recruitment to Tamil Nadu Higher Judicial Services. We expect that such advertisement shall be issued by 31st March 2026.
Obliged.
I will record produce copy. And you produce your original records of previous interview.
Lordship, it's not like we've been not calling for the every year. We've been on
You have
20.
you have been granting only 5 to 7% marks in the interview.
Lordship,
How the candidates will qualify? You have to take a pragmatic view. Non-Tamilians can't apply because they must know the Tamil language. The Tamilian candidates who are qualifying, you don't select them because you grant 5 to 7% marks to them. How do you expect?
Marks report we will produce before Your Lordship. That's not.
You produce the interview. We would like
That
to
I
see.
will. Lordship, meanwhile for 2026, apart.
6 years, you are only selecting 8 candidates.
Please.
No, they qualify. Only 8 candidates qualified, Your Lordship. It's not we selected. It's only 8
Even if they are
qualified.
qualified or not, they should release that notification at least every year as per my lord's order 4/1/2007, my lords. They never do that. Since because a candidate is failing, they never take out the notification at all.
Except 2025, every year we've been calling for the examination, Lordship. It's not like it's.
You will issue the advertisement. Go issue the advertisement. Otherwise, we will take away the selection process from there. If this is the way High Court is behaving.
Well, Lords,
The only thing is it had to be made easier than
Where
nothing.
the poor candidates will go. After all, there is an age group. If a lawyer, if an advocate will become 50 years old, why he should apply for higher judicial services? What incentive he will have in his career? If he to retire after 10, 12 years.
Lordship, then the only process could be it should be made easier, nothing else.
You comply with that, then we'll see. List it after immediately in April 1st week.
So, my lords, the notification will be taken out on 31st March, my lords. 31st March, the notification.
That ought to be issued.
Great.
Lords, may I request one IA, my lords, in the same bench of matters. That's IA number 66708.
That's why High Court is seeking permission to promote junior division officers now to fill up all the direct duties.
Only because
They can't deviate themselves, my lords.
We have already.
Lordships, All India Judges Association, the guideline Lordship had given at para 13.
Do not create an impression that you are unfair and not partial towards a particular set of candidates. Only because they are coming from bar. We have to be very pragmatic.
Very clear.
We have already reduced the bar quota. Yes. We have given promotional avenues more than sufficient. Now still you want to fill up all the vacancies.
That's not the intention, Lordship.
That is the precise intention. And if you find from the record, then we'll transfer the selection to some other IM.
So on date, I believe there is a vacancy of 95 posts at least in the direct recruits from the bar, my lords.
There is only 51, my lordship.
From the bar. That is my understanding and my information which I have. I think the amicus would be able to give us
We
a.
had to amend it because 7 years of experience, it had to be amended, it had to be sent to the government, and after that only we can.
Amendment for what?
Lordship, 7 years of experience to be for giving the examination. And there is also a clarification application which is also pending.
We will not say there is a judgment by the constitutional bench. You and your state both are bound by it.
Yes.
Don't invite contempt petition against yourself. As if you are obliging us.
Grateful.
It's the same bunch of matters.
Yes, item 35.
My lords, may I mention one IM, my lords? I'm representing Maharashtra Subordinate Judges Association. We have moved an IM, my lords, which is also registered. My lords, that may be placed or tagged in this matter. My lords,
matter are we talking?
my lord, this is regarding, my lords, compliance of Malik Malhar's judgment. In Maharashtra, my lords, 2024 yet not completed. Well, application 66708 of 2026, which we have filed in the present bunch of matters, the main matter. Only request is to have it, my lords, take up this IM whenever your lordship.
We not listed today.
Oh, my request is to, my lords, give me a date on that, because 2024 yet not complied by me.
So next date will list log. Item 35.
Wait, please. But I am appearing for the UPSC models. But I have made a chart of all those states which is the status of which is given.
Yeah, maybe then I copy it.
Yes, with this.
एक पन्ने का है?
Yeah.
Yes, sir.
What happened? How many selections we have been able to finalize?
Maharaj, we have done for Gujarat, Maharaj. 35. And Maharaj, next. Maharaj, ECMs which have happened is Gujarat, Telangana and Tamil Nadu. It's but Gujarat, Telangana is on 11th March, which has happened. Gujarat is 19th March, and Tamil Nadu is on 20th March.
No, Gujarat, you are saying, where are your remarks?
But it's Gujarat, if your lordship sees at the last column.
Revised proposal has been received on 27th February 26, considering the date of occurrence of vacancy as on 5/2/26. ECM to be held on 19th March.
Yes.
You have nothing finalized.
No, but it's that ECM will have to be taken place on 19th March. Gujarat.
ECM means what?
But it's the selection committee.
These are the dates where the UPSC will decide. Respect to each state. For example, Tamil Nadu is 20th March. So panel has gone to them, they will now decide. That's what he's trying to say.
What do you say about Tamil Nadu? Where is Tamil Nadu in this?
Yes, it's on the next page. It's the first item on the next page.
I appear for Tamil Nadu. We have to.
That is on 20th March 2026.
Now, is it the first proposal as per our previous order?
Yes.
As per your lordship's order.
We have complied with the lordship's order, my lord, and sent it up. They will not decide.
And Malod's Telangana is also done. Malod's Telangana is on 11 March.
So Gujarat, you will hold your meeting on 19th March.
Correct, Malod.
Tamil Nadu, you are holding on 20th March.
My lord.
And Gujarat and Telangana is done on 11th March.
Telangana is already done.
Yes, already done. Malod, that is item number 5.
Telangana was the matter where we passed a separate order.
Yes, Malod. But
it's wanted that order to be applied to all states.
Now, Malod, if your lordship sees Chhattisgarh, Malod, the ECM has already taken place, but the state has not appointed.
Yeah, correct. That's what he said.
And composition also they separate.
Who is representing Chhattisgarh?
But it's.
So as far as your state is concerned, Mr. Rodgi,
We are
they are
done.
doing it on 20.
Yes.
eh?
We are done.
Contempt has to be closed.
Lord, contempt will be closed below account.
Contempt is.
Yes.
There is no contempt.
That's right. Yes.
But there are two more states which your lordship will need to point
35.2
out.
is the contempt has to be closed. 35.2 is the contempt.
Say, write down. This matter pertains to appointment of Director General of Police. In terms of the mandatory guidelines laid down by this court in Prakash Singh case. There were some doubts with respect to the eligibility of the officers who could be empaneled for the purpose of zone of consideration. Those issues were resolved by this court-wide order dated February 12, 2026. In compliance thereto, the state government has sent a press proposal on 23rd February 2026. The said proposal shall be considered by the UPSC in the meeting coming on 20th March 2026. The process to comply with the directions of this court in Prakash Singh case, from others having been initiated and reached at the final stage, we see no reason to entertain these contempt petitions, which are accordingly disposed of as having become infructuous. Just give the contempt number.
Yes.
So we, however, impress upon the
35 point.
UPSC to ensure that the meeting is held on the date fixed and recommendations made in that meeting are implemented without any delay. Without any delay.
Similar request state of Telangana. Bihar will not also.
We are coming, one by one will come.
It is not there in the list, Lord, but I may just tell, I have a notice of contempt. What happened, Lord, my DGP was there till 19/12/2024.
We will just deal with one by one.
State of Telangana is. My name is not in this list, therefore I want to say something, Lord. But although notice has been issued to me, my DGP was there as per the procedure prescribed up to 19/12/2024. But in August 2024, the DGP was asked to come on central deputation and we had to relieve him. And for 3 months on an acting charge, we put another DGP while we sent the proposal to the UPSC. The UPSC granted the proposal on 25/11/24 and we appointed the new DGP Milord on 7/12/2024. So these facts have not been brought on record by the contender at all. And Milord, yet a notice was issued to me, Milord. So therefore, I want to say that 2024 now for 2 years, as per the empanelment by the UPSC, Bihar DGP stands appointed on 7/12/2024. So that name is not
7/12?
7/12/2024, Milord.
24. So 2-year term will expire in December 20.
December. So I'll have to initiate the process again. But Milord, the notice is pending on my.
What is the notice pending?
No, notice was issued, Milord, for the entire contempt petition in diary number 41923 of 2024.
Diary number?
41923 of 2024 was what was given to us. If it has been numbered now, Milord, we do not know, Milord.
All right, all right.
So therefore, I want to.
ये एक स्टेट का ना नाम लिखो, हेडिंग बना, उसको अंडरलाइन करो. सेकंड लिख दो, बिहार लिख दो.
I'm very obliged.
In respect to the state of Bihar, whom I just particular pointed out by Sri Ranjit Kumar Senior Advocate, representing the state that earlier there was a regular Director General of Police in the state of Bihar who was taken on deputation, central deputation.
Yes, in the
August-
middle of his tenure.
Before expiry of his tenure,
Please.
that is in August 2024.
Yes, Lord, and appointed a DGP CIS.
Thereafter, an acting Director General of Police was, but then thereafter, the charge was given.
A charge was given or acting charge was given.
Charge was given as an ad hoc,
Stopgap arrangement.
as a stopgap arrangement for a period of 3 months. And meanwhile, a regular Director General of Police has been appointed
On 13/12/2024,
on 13
for the empanelment by the UPSC.
on 13/12/2024 on the recommendations made by the selection committee of UPSC.
Which was done on 25/11/24.
It's all right, it is sufficient.
So therefore not.
Let's go. The 2-year term of this regularly appointed Director General of Police is yet to expire.
Yes.
Hence, no occasion arises to initiate contempt proceedings against the authorities of the state of Bihar. The contempt proceedings toward that state are accordingly dropped.
Very obliged, very grateful.
Now,
But in the state of Telangana, because my lord, the meeting has already happened, my lord, we are also figuring in the contempt case as respondents 7 and 8. Item 35.19.
No, now you have received the
31 point.
Yes, we have sent a recommendation.
It would be similar to the Tamil Nadu matter your lordship stated, my lord, that after we get the proposal from UPSC, the state must act forthwith.
So maybe be excused, Lord. May I be?
we know that it is 12th is today, and yesterday only they have sent the recommendation.
Yes.
That's correct.
You have to only comply with now those
Yes,
recommendations.
I'm only saying, I'm bringing it to your lordship's notice that there's a contempt filed against Telangana. where-
Contempt we are dropping, but you give effect.
Yes.
As per the regular DGP, every state requires a regular
Yes.
DGP. तो तेलंगाना में लिख दीजिए. We are informed by Land Council for UPSC that a fresh proposal from the state government was received on 23rd February 2026. That has been duly considered by the UPSC and recommendation made yesterday, that is on 11/3/2026.
Correct.
Then say Mr. Reddy, Land Senior Counsel representing state of Telangana state that recommendations received from the UPSC will be given effect without any delay. So that being so, the state of Telangana has also become infectious. The contempt proceedings are accordingly dropped.
Grateful, my lord.
So it's Chhattisgarh, the recommendations has been given, but there has been no decision.
Just a minute, Nishan ko lagane ke liye. Bihar is done. Yes, now who is Chhattisgarh?
Chhattisgarh, whoever, the recommendations has been given, but no decision has been done by the state government. But there are certain.
Anyone appearing for Chhattisgarh?
But there are, apart from that, certain states where proposals.
The Chhattisgarh guiding body. Land Council for Union Public Estimation informs that the state government has not appointed a regular Director General of Police from the panel of UPSC. Acting DGP is working since 4th February 2025. He further informs that the UPSC in its meeting held on 13 May 2025, right?
Yes, ma'am.
Did you recommend any name?
But as we recommended a list of 3. The recommendation is of 3 people.
3, but they have not implemented.
No, they have not implemented.
That the UPSC had recommended a panel of 3 names on 13 May 2025, but no one has been appointed. You also slept over the matter. Now only last week you sought explanation.
Yes.
Should have done something before us.
Yes, ma'am, we should have.
The UPSC has now sought an explanation from the state government on 3rd March 2026. इसी में सब paragraph. No one appears on behalf of state of Chhattisgarh. So before we take any coercive action against the state authority, 1 week notice is issued to the state of Chhattisgarh through its chief secretary to show cause as to why UPSC recommendations dated 13 May 25 have not been implemented so far. The Advocate General for the state of Chhattisgarh shall remain present in court to assist us on the issue. जहाँ पे आया था ना चीफ सेक्रेटरी का have not been implemented so far, and why the acting DGP be not restrained from performing the duties. Then say the Advocate General shall remain present in court. Date बताता हूँ एक
Then there are state of Uttar Pradesh and Jharkhand are two states where they have made state acts. And your lordship says in one case, in this case itself,
Uttar Pradesh has done what?
They have done a state act. And Maharaj, in 2019 4 SCC 13, your lordship had said in paragraph 6.2, 6.7, my lords, that any legislation framed by any state or the central government running counter to the direction shall remain in abeyance to the aforesaid extent.
UP and who is the other state?
Jharkhand.
Looks in the case of Jharkhand, we have challenged that legislation and it is at 35.23. In the case of Jharkhand, we have challenged that and that is listed at 35.23 today.
You have challenged this law?
Yes, my lords, because that was in complete violation of the Honorable Court's guidelines.
State of Jharkhand.
State of Jharkhand is there.
Well, we have brought in rules, my lords. In fact, if your lordships sees, my lords,
And who is for UP? Thakur?
Yes.
Are you there?
Yes.
What law have you enacted?
But we would be sending the proposal in 2 days, yes. The proposal and the panel of names from the state would be sent to the UPSC within 2 days. We have received a letter on 6th and 18th of February. So for the moment, panels, we are not.
We hope the states will not create an embarrassing position for themselves. How can you enact law like this? The first appointment has to be of a member of the All India Services.
Yes.
The All India Services officers will be governed by a law enacted by on pan India basis.
Yes.
You can't have the state laws. Tomorrow you will start imposing conditions that he must know so and so language, he must like this. The state originated conditions can't be made as the criteria of eligibility. In any case, the union government or UPSC or any state government, all of you are bound by the criteria guidelines laid down by this court in Prakash Singh.
Yes. But
So how can you run away from that?
in Prakash Singh, my lords, the guidelines which are lordships laid down, where, my lords, to operate till, my lords, the state comes up with a legislation. Ultimately, my lords, police is a state subject. Your lordship said, my lord, in Prakash Singh, 2 places, that these guidelines will operate till a state comes up with a legislation. So we have brought a legislation in place, my lord.
All right. That is only till that you will frame a law. Can you frame the law or a criteria which is contrary to the All India Civil principle?
Sorry, my lord.
Who is going to select your DGP?
Well, we have a nominating committee. 6
You nominate your ex-politician, B politician, chief secretary, and they will select.
The retired judge of the High Court, my lord, is the chairperson of that committee. We have a committee in place, my lord. Even I think UP also has a committee in place, my lord.
As amicus,
What was the procedure?
As amicus, I wish to make a submission, because I am not kept in the loop
by the UPSC or anyone, my lords, so I'm wondering why I am here. I had made an application as far back as in 2020. I had brought it through the court's notice also on 2-3 occasions recently, my lord. IA 59862 of 2020, where a suggestion has been made as to how this honorable court may manage this matter in future so that every DGP appointment doesn't come to this honorable court. So the suggestion in this application was twofold. One, that the monitoring of the directions in Prakash Singh should be left to individual high courts with the assistance of their own amicus curiae as far as implementation of the directions are concerned. And all state legislations which have been passed after Prakash Singh will be tested in this honorable court to see if they are in accordance with the directions of Prakash Singh.
I think that's very that's a very practical way out and the very fair way of.
Lordship, because otherwise every DGP, your lordship, is having to deal with, your lordships are having to sit on a bench of 3 judges, and every 2 months, every 3 months, acting DJP, etc. Therefore, my lords, this application, which is 35.19 on your lordship's list. Yes, my lord.
Just continue, Mr. Raghuva.
Yes, my lord. Therefore, the suggestion is that if my application is considered by your lordships, the case could be managed in a manner where this honorable court mainly concentrates on whether the legislations passed by the states are in accordance with the directions in Prakash Singh, because those directions are based on Article 21. If they don't accord substantially with the directions, little play in the joints is something different. But if they don't accord with the judgment proper, then they are unconstitutional. Those may be struck down. But individual cases, my lords, have to be managed by the High Court. Your lordships can't be troubled like this.
I think you should know. This concern.
That's I think, Professor.
Lordship.
My lords, if I just permit, my lords, if I may just mention, I'm appearing for state of Chhattisgarh, my lords. My lords have passed some directions, my lords.
That's right. You are not. What are you doing? Are you not within the ambit of the direction?
My lords, we are, my lords.
Then?
My lords, I will just seek instructions. My lords, may I just exempt the chief secretary from. My lords, I'll apprise my lords with all the instructions, my lords.
Council for the state of Chhattisgarh seeks and granted 1 week time to have instruction.
Please, my lords.
The microphone.
Prakash Singh has also filed this application.
Yes, Mr. Prakash Singh has filed an application.
Oh, now he doesn't want UPSC to select.
You know, he is proposing a kind of a collegium of state chief minister, opposition leader, etc. Because that may or may not be workable.
It may not be workable.
It may not be
It will
workable.
never be workable.
Your lordships had issued no.
The UPSC may continue minutes, but the only question is it should be monitored at the state level. This collegium thing will not work.
Well,
Eventually, for DGP, you need a central authority who can have a pan-India criteria, directions and guidelines.
Yes.
Therefore, UPSC appears to be in that.
Yes.
Constitutional body, and there are no allegations against UPSC.
No.
I think they should continue.
Yes.
The only thing is that rest of the directions, which are basically in a way, what he is pointing out in application is a way how the states are in contempt in Prakash.
That's
right. That's a different
That's right.
altogether issue. That we can take necessary measures.
May I just request I appear for Mr. Prakash Singh? Mr. Prashad Bhushan generally appears, but he's not here today. That application that he's filed is essentially seeking modification of your lordship's directions in paragraph 31(2), where your lordships have said UPSC will prepare the panel and thereafter the state will select. What Mr. Prakash Singh is saying that instead of the state selecting, let it be the composition of the selection committee should be pari materia to the composition of the selection committee for the CBI director. For the CBI director, it happens to be the Prime Minister, Leader of Opposition, and the representative of the Chief Justice of India. So pari materia, he's saying that let it be the Leader of Opposition of the state, the Chief Minister, and a representative of the Chief Justice.
I don't support that.
Not the suitable solution. Let's not drag the Chief Justice and.
But that's the composition for the CBI director. Nobody has any qualms with that composition for the CBI director. That's the only.
But an RD appointment, the consideration, the criteria can be altogether different. At the state level, the 24, 25 DGPs are to be selected. That should be with UPSC.
Yes, well, UPSC prepares the panel. It's about who selects from the panel, because the UPSC prepares the panel of 3, let's say, notes. Then finally the state has to select. Today, I'm just requesting if your lordships may keep that application pending. Your lordships have already issued notice on it. Today, I'm only requesting your lordships may keep that application pending. Mr. Bhushan appears for him, and he's not unavailable today. So that's all I'm requesting.
So pending is all right, but we need to dispose of these matters ultimately.
Because my different perspective on this is this. Once the UPSC prepares the panel, the state should have the choice, because whether it is Home Secretary or DGP or Chief Secretary, these are all ultimately posts of confidence. So there the decision making cannot be broad based.
Confidence, and there is no need to doubt a elected government. After all, people have
that amount of choice. I would submit, any elected government must have to appoint its principal officers.
Very right.
But on behalf of State of West Bengal, I support what Mr. Raju is saying.
Of the political governance, and that part is taken care when the UPSC prepares prepare a panel.
The panel is done, then the choice should be of the political executive.
That's right.
Now, what is the position about other states? UPSC.
Yes.
What is the position about other states?
But Punjab and Himachal has not responded.
Punjab, Dr. CV is there. Punjab.
And Manipur, they have not given a proposal at all. And there are 3 states, which is Arunachal, Goa, and Mizoram. They have not given a proposal at all.
Here's my next heading now.
Just one more thing.
The paragraph about the states of. Now tell us one by one. In your list, you can start on the top.
Yes. But it's states of
Punjab,
Himachal, Punjab, Manipur.
Just a minute. Himachal Pradesh, Punjab, then Manipur.
And the Arunachal Pradesh, Goa, and Mizoram, they have not given proposals at all.
According to Learned Council for UPSC, the states of so and so have not forwarded any proposal to the UPSC for empaneling the officers for appointment of their respective DGP. Prima facie, these states are in contempt of the directions issued by the court in Prakash Singh case.
Well, it's,
There are two states, which is Uttar Pradesh and Jharkhand. But they are, I think Uttar Pradesh is saying that.
Those who have enacted the law separately will come to that.
Yes.
Well, not when those who have complied, not contempt.
before your lordship dictates, I have to say.
Lord,
a
State
sentence
of
about
West
Punjab.
Bengal has forwarded the recommended
Punjab.
names, Lords.
Well, I have to say a sentence about Punjab before your lordship dictates. Whereas Punjab has passed a law which is exactly in conformity with the lordship's directions. That law was passed. Unfortunately, the president has withheld assent.
5.23.
No, Punjab has passed a law which says what?
Passed the Punjab Police Amendment Bill 23. We have passed the Punjab Police Amendment Bill 23, which provides for a empanelment, independent empanelment committee chaired by a retired Chief Justice or a retired judge in conformity according to us of a lordship's order. That bill was, below at the same reference withheld by the president. I mean, refer to the president.
So therefore, there is no law as on date. If there is no law,
No, we in fact passed a law in conformity with Prakash Singh's order, but that was withheld by the central government.
you can't enact an extra constitutional law and keep it pending and to take a shield against the contempt proceedings. If you have a law, valid law, you enforce it, no difficulty, unless that law is set aside. But if you don't have your own law in terms of Prakash Singh, then you are bound by Prakash Singh.
It went a little further after that withholding. We challenged that withholding also. That is also. Chance to reconsider. We challenge the withholding. Your lordship may. But the lordship.
There are issues with constitutionality of your legality of your law that you resolve at your level, whatever is to be done.
That writ is pending. Notice has been issued. But what my lord is now saying is that without the law, because the law is not into force. Now, my lord is right. So, in that case, your lordship will allow the state to reconsider the next date, because I'll find a way out. Because we were hoping that the law will solve the problem exactly as per your lordship's order.
Directed to Showcase that in the absence of any valid law having been enacted by them in terms of liberty granted by Prakash Singh judgment, why appropriate action under the Contempt of Court Act be not taken or withholding recommendations for appointment of the respective DGPs on the basis of out of the panel to be prepared by the UPSC. Then say post this matter after 2 weeks on so and so date. Chhattisgarh wala matter be 2 weeks ke baad same date पर.
For the state of Himachal, my lords, I am appealing. For the state of Himachal, we have already enacted the proposal amendments and they are not under consideration. They have already been finalized by the. Give me 1 week time and I'll produce the
Himachal Pradesh. Next paragraph. In respect of the state of Himachal Pradesh, State Council seeks and granted 2 weeks time to have instructions regarding forwarding the proposal in terms of the request, in terms of the letters dated 18th February 2026 and 6th March 2026 received from UPS. Same date, next paragraph. The state of Jharkhand, state of Uttar Pradesh and Jharkhand have also come up with the plea that state laws have been enacted. The virus of both the statutes.
Just point out one fact, my lords.
on 3rd of July 2018, in the Prakash Singh matter, this Honorable Court in fact said that all the rules and the laws which would be framed would be kept in abeyance.
Yes.
That's the reason why, in fact, we today are not pressing on the law and we are ready to send the name within the next 2 days.
Yes.
That order, may I just?
The point is that, Mr. Thakur, if there is no your state law governing this appointment, then direction in Prakash Singh will have to follow.
Absolutely. In fact, this Honorable Court, as early as 2018.
Although we have made that and Jharkhand will show cause as to why the proposal for appointment of Director General of Police as per Prakash Singh's case have not been forwarded to UPSC.
But just one request, Lord. Andhra Pradesh I represent, Lord, we complied last year. We are not in the list of the, and Lord, therefore, to that extent, Lord, 35.19, the contempt may be closed.
Andhra, you have appointed a regular person.
Lord, yes, Lord, we sent the proposal in time within the time and the appointment happened, not so that we are not in the non-compliant list.
Senior Counsel for State of Andhra Pradesh state that regular DGP on recommendations of the UPSC has been appointed a year back. Hence, the consent proceedings against the state of Andhra Pradesh are also dropped.
Same would be the position for state of Karnataka also. We have also appointed members from the panel.
Same order in Karnataka.
Please, that's great. Because state of West Bengal.
We are fixing a rate. Please tell us that wherever you have enacted your law, valid law, and foreseeable law, you go ahead with that. Otherwise, you follow.
State of West Bengal has also submitted the recommendations to the commission, not for commission to
list. IA number, Mr. Raju Ramchandran, next date we are listing your IA.
Yes, well, if it can be listed standalone minutes so that can be.
Say on the next date of hearing, the registry directed to list IA number 59862/2020 at number 1. And IA number 150155 at serial number 2. And IA number 150155 and 67359 at serial number 2 and 3 respectively.
And all these affidavits which your lordships have directed them to file minutes, they may all be served on amicus minutes so that we can.
Can we also?
Yeah, that's right. Meanwhile, all the state governments, all the governments representing the state governments, union territories, will submit their reply affidavit, a copy of their reply affidavit to
Mr. Aljo Joseph is the advocate on record assisting.
Can we also get a copy, Manoj, of the affidavits which is filed so that we can? Can we also get a copy of the affidavits which they are filing? Whoever that they are filing.
They are bound to give you.
It's whatever they are not
supply the state governments or the land state council will ensure that copies of the respective affidavits are supplied in advance to land amicus as well as to land council for UPS.
Lord, state of West Bengal has submitted the proposal to the commission.
Lord, what was properly conveyed to the document. There is a law which was enacted in 2023. Lord, it contained a provision for empanelment by a committee which is headed by a former Chief Justice of the nominee of the Union Public Service Commission. And
we are not impressed by this expression, Mr. Giri, that a former Chief Justice. There are some restraints on me. I don't want to comment on Punjab and Haryana. But the advice will be that till they enact an appropriate law. Yes, if once the law is enacted, no difficulty. They should follow the directions of this.
Law was enacted in the sense that the bill had been passed by the state legislature. There was an assent.
Lord, State of West Bengal has submitted the proposal, Lord, to the commission.
That has been challenged in the repetition before your lordship. That is
These proceedings are not to resolve any dispute with respect to the state's competence to enact that law or Honorable President's right to withhold that. We will not touch on to the issue. These are not the proceedings before. So long as there is no valid law, you are bound to follow Prakash Singh. That's all.
Lord, we make a response to this. We thank you, Lord.
My lord, Mr. Dwivedi is there for State of West
The
Bengal.
UPS has written to the state asking for a panel.
My lord, sir,
2 weeks will
for the, my lord, for the
Lord,
state,
State of West Bengal has submitted the proposal.
Yes, ma'am.
my lord, sir, for the,
State of West Bengal is more busy in transporting the DGPs to Rajya Sabha.
Because we have submitted the proposal, Lord, we have submitted the proposal.
So we can expect a stable DGP because there might not be a vacancy in Rajya Sabha.
Yes, Lord.
my lord, sir, for the state of Manipur, my lord, sir, we issued show cause. My lord, may I request that I'll take instructions by next week, my lord, for the time being, my lord, may dispense for.
Granting 2 weeks time to all of you. We have not, contempt notice has already been issued way back.
I understand.
Those are pending proceedings. We are disposing, we want to close those proceedings.
Please.
Some of the states we have closed today.
Yes.
There is no need for us to take any punitive or any harsh action against
I
them.
understand.
Please comply with. If you have your own law, follow it. If you don't have a law, follow precaution. That's very simple formula.
Please.
Grateful, my lord.
Yeah, 36.
This is, my lord, the farmer suicide matter.
Yes.
My lords, we have prepared a comprehensive affidavit on all the policy interventions that have been made. We could not file it. Would your lordship permit us to?
This is the reply or what?
My lords, it is an updated affidavit.
Status report kind of.
It has like a status report on various schemes, dividing it into 6 broad parameters. Farmer insurance welfare schemes are one aspect of it, natural farming. So there are 6 different silos in which we, your lordships had indicated on the last occasion, your lordships would like to see what is the current policy initiatives. Yes, my lords. My lords had on the last order give.
Additional solicitation of India presenting the state
We have served copies to other side.
Not yet.
Yeah.
No,
The comprehensive counter affidavit from status report.
Maybe. Yes, now.
Morning.
We are using the word counter affidavit come status report.
My lords, it's an additional affidavit.
All right,
Additional affidavit comes status.
Giving full details of implementation of various schemes in this state of Gujarat. So let be said affidavit be filed in the registry with advance copy to learn counsel for the petitioner. Post the matter for further consideration and so on and so forth.
Grateful, man.
Great.
Lordship, in item number 37, Ms. Kothari is appearing online.
My lords, I appear in this matter, my lords. My lords, this is a matter wherein, my lords, we have challenged NACO's blood donor guidelines. Because, my lords, these blood donor guidelines, if my lords can see at page 49 onwards, there is a permanent ban, if I can just point out, page 49, number 12, for example.
My lords, I must also point out, my lords, on 14th May 25, your lordships had orally directed us to reconsider. So the experts have reconsidered the whole aspect and there is a reconsidered opinion, my lords, placed before your lordships by way of an affidavit. They have,
In fact,
they feel that if this will be diluted, this will be injurious, my lords, to the recipients and my lords, we can't
In
dilute it.
fact-
Presently is the opinion of the experts before your lordships. So lordships may have to
In
consider
fact, my
that.
lords, in the additional affidavit of the union, which my friend refers to, only the committee's constitution order is there. The order of this committee, reasoning given by the committee to reiterate, none of that has been produced. My lords, our submission is that if my lords just for a moment can see the manner in which these guidelines put a blanket ban based on a person's sexuality and gender identity.
No,
Not
a good one single good reason that we should issue this direction. Directions
Yes.
are not suppose after all there are millions and millions poor people, vulnerable classes who take the free blood facilities from the blood banks. The rich people, those who can afford private hospital, those who can spend, and including even the government officials who are getting handsome salary. All of them have the advantage to go everything of their choice. It is the poor state of people who depend upon largely sustain on free medical facilities that they will survive on this blood also. Why these poor people should be even if there is a 1% chance of any infection, why they should be
My lords, there should not be even a 1% chance for anybody. My lords are right. There should not be even a 1% risk of anybody. The core issue, my lords, is once blood is donated by anybody, the blood donated has to be tested and only then used. In fact, after every blood donation is done, HIV testing is done on the blood. NAT testing is done on the blood. In fact, the state says, my lords, the two submissions, can I just make?
In the case of donation and acceptance, both things are voluntary, right?
The donation and acceptance are both voluntary, yes.
You will
Yes.
donate voluntarily, somebody will accept
Yes.
your blood voluntarily. So
Yes.
we grant you liberty that whosoever on the earth wants your blood to be taken in the need, God forbid if somebody is in need and he or she wants to have your blood and you are willing to donate, they will accept it. But
My lords, that is not how can I just make one submission? My lords, today a heterosexual married person donates blood. That person is not asked a question, when is your last unprotected sexual act? The risky behavior is the sexual unprotected act, not my identity. There can be a transgender person, a heterosexual person who may have had a risk based behavior. Would that person's blood not be yes?
We would have appreciated if you had come to us that look here, there is so and so category of persons who are permitted to donate blood, and after donation their blood is also not identified. Or
that is exactly what I'm saying, my lord. That is exactly what I'm trying to say.
That you should have asked for a direction to us that please don't allow them to donate this blood, don't allow them to supply it because it risks the life of so many innocent people.
My lords, our submission is that any risk behavior.
In our case also it should be allowed.
No. That is not our submission. My lords, that is not our submission.
All right, leave granted.
And that's only one submission.
We don't have time for it.
Man, only there's a technological.
We will get later on. Only enough time for the people to decide cases.
Man, it's only that the NAT. I'm just.
Besides, also like we have granted legal hearing.
Grateful, man.
So they could luxury litigation घूमते रहते हैं.
No, I'm only saying that there's a technology which is there, which will make it very easy to determine everything quickly. The NAT.
We will lay down, list it before a 5 judge bench, 3 judge bench once day.
Grateful, my lords. Grateful.
My lords, Senior Advocate Ms. Menaka is leading us in this matter. My lords, she is available online.
Good afternoon, my lords. I'm so sorry, my lords, that I'm not there physically. My lords, this pertains to Schedule 5, my lords, of the Constitution, which pertains to administration and control of scheduled areas and scheduled tribes. My lords,
Please wait. Ma'am, please wait.
Nowadays, now you have started already appearing from line.
no, my lords. My lords, just this one matter, my lords. I was waiting for this matter and then.
There is an interruption in your line.
I'm so sorry, my lords. I'm so
You are
very
afraid
sorry.
of the busy schedule. You have always been appearing well in advance in court, in particular
My
in
lords,
court number 1.
my lords, all I can say is, my lords, I'm very sorry about not being there today.
No,
It's
it's
just
all
in
right.
this one matter. I'm extremely sorry, my lords.
No, it's all right.
My lords, this pertains to Schedule 5. If I may just take you to the 5th schedule, my lords, of the Constitution. And if I may just read, my lords, with your permission, Schedule 5, Part A General, Subclause 3, my lords. If I may take you to 5.3. Your lordships have this, my lords. Report by the governor to the president regarding the administration of scheduled areas. The governor of each state having scheduled areas therein shall annually or whenever so required by the president.
It can't be enough, half an hour or so.
Yeah, my lords, this will take a little bit of time, my lords. This will, and this pertains to the Tribes Advisory Council.
Post matrimonial
And my lords, may I just say this, that in the Constituent Assembly debates, Dr. Ambedkar says that the Tribes Advisory Council should be responsible and should be consulted when it comes to affairs pertaining to scheduled tribes, scheduled areas.
Matter for finally for a cruiser's bench.
Grateful, my lords. I'm so grateful.
Move there item 40.
Because this says only 3997 is fix this schedule.
Both, yes. Now, Manas, your lordships has listed Manas SLP 3997, which is only the symbol matter. There's also the defection matter, Manas, which is item 40.
What?
40.
Texted and
The
the
defection matter. Now, Manas, that's been separated.
One is there are SLP 1644 to 166.
One is the challenge, Manas, under the schedule because there is no split.
Correct.
And Manas, merger didn't happen. So if they are, Manas, this whole government is based on the fact that even though there was no merger, they are continuing. So if the defection, Manas, appeal is allowed, nothing else survives. That's why you listed both matters. Now, Manas, only one matter has been listed. Manas, give us time so that we can be done with both matters.
What is the other matters not listed, blood, as Mr. Sibal says.
Yes. Both are listed.
No, both are listed.
40 and 41. But says only SLP 3997.
And CP1 is not listed, blood.
3997 is also listed.
But it says only 3000 SLP. It says, register says only 3997 SLP is under.
997 is also.
There's a note in the cause list is what I'm saying. Manas, we are ready to argue as far as we are concerned, Manas.
No, we are also ready.
Yes.
The other SLP is 1644 to 1662.
That's correct. That's the defection matter.
That's a defection matter.
Which is also before the court.
That is also listed. This is also listed. And then SLP 4 to 48 is also listed.
Correct.
So which one is not listed?
No, well, that's not listed, I believe.
It's NCP matter.
That's the NCP matter.
Only the Shiv Sena matters and
These are separate. This is the Shiv Sena matter, that's the NCP matter.
That's the NCP matter.
4248 is NCP matter.
NCP matter, that's a different matter. Matlab, where your lordship has granted some kind of an interim order.
NCP.
Your lordships, this said last time that the NCP matters are separated.
No. One to follow the other.
But they have to be heard on the same day. You said they are
One to
separated,
follow
but
the
will
other.
be heard on the same day.
The lordships may see the last
Lordship.
order.
They said follow.
Below 12th November 25 order may be seen.
Yeah.
12th November 25 order may be seen, below. If your lordship will see that order, 12th November 25. May I pass on, Lord, if your lordship? 12th November 25.
Yeah, this is the order. I have it with me.
Yes.
Below, your lordship will find item 1 is a contempt, then rest of the matters. Having understood the nature of these matters, the Assistant Land Counsel, we find there are two sets of petitions, namely matters between two groups of Shiv Sena political party, SLP 1644 and then 3997. And two, the matters pertaining to the group in NCP political party, SLP 4248, 11820 and 7957. There is a possibility of some of the issues being common overlapping. Hence, it is resolved that firstly arguments will commence Sena
followed by NCP.
That's correct.
Yes, that's right.
That's right. Then, Lord, each party was allocated, Lord, 3 hours.
That's right.
Yes.
And that's how it is, Lord. And then 2 hours, etc., etc. Nodal council.
But then what is the problem? All these matters are there today also.
Lord, that NCP, Lord, which is to follow, is not listed.
That doesn't matter, Manoj, because the NCP matter is somewhat different, Manoj, even though they are just.
This order, Mr. Sibal, SLP bunch of 1644 to 1662
Yes.
are to be taken up first.
Yes.
That's correct.
Yes, that's right.
Yes.
That's we are ready, Manoj, as far as no issue at all.
No, somebody said that listing matters for. So we can start it now.
All right.
So then can we suggest to take the disqualification?
Well, let's take the disqualification matter first then, Manoj.
Lord, may I
As per that order, 1644 to 1662.
Yes, that's the disqualification matter.
We
We have filed our written submissions in this. We've given a list of.
May I suggest, Lord, may give us a clearer day. There's not much time left. Next week is a constitutional bench. After that, Lord, if your Lordship may give us at least a clear day, because it's 3 hours and 2 hours. Even if 3 hours is not given, smaller time is given, at least we have some clear day, Lord, we can start.
Yes.
That problem has not come for the last 1.5 years.
Therefore, let's start. We will spend at least 1 hour today. We'll sit till 4:30.
Very well. All right. Hmm?
Be there. Let me know.
Issues are.
Well, the broad issues are, Malas, that there was, according to us, Malas, under the 10th schedule, there was no split in the political party. The split was in the legislative party. Malas, there was a faction which was led by Uddhav Thackeray. Then, Malas, the other faction, Malas, they were taken to some other place outside of Mumbai, Malas, Gujarat, Malas, and they said that they are splitting. And they got members of the Legislative Assembly to pass a resolution. Right, Malas? Our case is, Malas, that split cannot be recognized under the 10th schedule because under the 10th schedule, there is no split now. Malas, it is only a question of merger. So, Malas, that merger must take place on the day when they went to Gujarat, because that's the relevant date for the purposes of the 10th schedule. It is their own case that there was no merger. Right, Malas? Then they filed, Malas, before the Election Commission
a petition saying that they are the political party. Right, Mullah? That matter is still pending. Ultimately, the commission decided, Mullah, against us as an interim matter. Your lordship said that in the judgment of this court, your lordships came to the conclusion that the election commission cannot decide on the disqualification only based on legislative majority. And the election commission decided based on legislative majority. So that is directly contrary to your lordship's order. That constitution bench order. So therefore that order has to go. And their lordships will have to decide whether there is a split in terms of the 10th schedule, which is not recognized. There is indeed no merger. And therefore they are not entitled to be members of the Legislative Assembly at all. Fortunately or unfortunately, that matter has never been decided. So they are continuing in government, which is why we've been saying, please hear the matter and decide this matter, Mullah. This is
Matter has not been decided.
this very split matter, Mullah. Because but if this is decided, Mullah, in our favor or against us, whatever it is, then the consequential order will follow. But the symbol can't be decided first and the split will be decided later. That's the question, Mullah.
Disqualification, speaker rules are legislative.
So fine, this matter is pending since 24.
That's right, Mullah. That's why we were saying, Mullah, that please hear us on a given date, Mullah, and decide the matter.
Here, the speaker says because they are legislative.
Majority, they are the party. How can the speaker say that?
So therefore, let us start systematically. Somebody someday this will have to be heard.
Correct, Mullah. So therefore, Mullah, we have no problems with that.
If you are ready and the total hour being 3 hours for all the matters, you tell us this matter how much time you will take and you can finish it. Then.
Mullah, I would say that I will take 2 hours in this matter.
2 hours, how can 2 hours be there?
All right, you give me whatever time, I'll take that time.
You can wind up very well in 1 hour.
All right, 1 hour. All right, Mullah, all right. Your lordship says so, I'll wind up in 1 hour. I've never, Mullah, extended.
Give the star arguments.
Well, we have filed our written submissions, Mullah, quite frankly.
Supplement them with a detailed note.
No issue, Mullah. I'll finish it in 1 hour. It's not really a very complicated matter.
If you want today, we will grant you. Today, if you want on some other date, we will fix a date. Whatever way you want.
It's up to your lordships, Mullah. Up to your lordships. Your lordship, I can start today, except that they will take time. Then there's no point, Mullah. Your lordships is sitting in constitutional bench. I can start today.
So therefore, both of you decide. Otherwise,
we can start.
Keep it a day after the CB. After next week, Lord, if the CB is over. After that, if your lordship will keep it, Lord, every day at 2 o'clock. We try, Lord, and conclude it. Because it's our case that in this matter, Lord, there is no split. It's an intra-party issue in which a new leadership emerged. That's our case.
Anyway, those are the rival contenders.
That's correct, Mullah. Correct.
That issue.
My suggestion is, Lord, on a clearer day, at least at 2 o'clock, after the CB, Lord, we try and conclude it in an hour each. If that is what Lord said, it's not so difficult. Because ECI order is there. We will show it from there. It's not an original matter.
So from our side, we can continue on today. Maybe if we don't get time tomorrow, then day after, or whenever we get at the earliest, we can start it. But if you want a date of your choice, both of you.
No, Mullah, I'd rather start then, Mullah, if this is the case. Because if your lordships are continuing tomorrow, Mullah, it's fine. We'll continue.
Continuing, yes. But if we get to tomorrow, we will hear tomorrow also. If we get a time after 2-3 days, we will hear in 2-3 days. Whenever we get time.
Mullah, may I suggest this? There is a summary note. Mullah, there is a written submission. There is a summary note. If your lordships go through it, Mullah, it will take us no time at all.
Where is that summary?
Filed on 16th of January.
This 15th of January.
16th, yes, in item 40, yes, we filed it on 16th of January.
Where is that note? Shant Patil.
Yes, correct.
So, Mr. Sibal, you want us to go through it first and then hear it?
It's better, Malas, because you'll get an idea, Malas, as to what the matter is out, what the conspectus is. It'll easier for me to convince your lordships, Malas, one way or the other.
Mr. Sibal and Senior Counsel for the petitioner has at the outset pointed out that a summary of written submissions, the latest summary of written submissions dated 16 January 26 has been filed on 20th January 2026, which is on record. He submits that we may firstly go through the summary of written submissions. These written submissions followed by the oral arguments.
Yes, yes.
As requested, post the matter on so day. The registry directly to send.
But give us some clear time, Malas. That's all our request is.
The residential office. Well in advance. If you have also seen
that my note was ready, I'm not sure if it is filed, but I will ensure Milord it is before you.
Students also may file their
Notes will have that.
meanwhile, and that may also be sent.
It will be circulated.
Camp offices. Post this matter on so date at 2 p.m.
Grateful.
That's fine. That's fine. My lord will give the date depending on the calendar.
2 p.m.
Yes.
Find out a date.
Deeply.
Just 2 p.m. then you can start, and maybe that by 3:30 maximum you can wind up.
That's fair enough. That's fair enough. Deeply obliged.
Grateful, very grateful.
Yeah, that's fine.
Any matter.
Pollution matters. Your lordship will take the vehicular issues, my lords?
Yes.
Please, my lords. So, my lords, and your lordship said. So, my lords, your lordships may consider taking the compliance of vehicular measures, MCD toll, and ECC issue that your lordships had directed qua order dated 21st of January 2026, my lord.
But before that, your lordships had told us to compile the suggestions for listing, and we have circulated a note for the case management. Your lordships had told us to do that.
That's it. But that note we are.
We filed yesterday. We have copies. It reflects in the office report. Courtmaster, can you hand the copies to? You have a copy, no? I have.
Already. हमारा CRP का note दिया हुआ है. Maybe please note.
23rd February, your lordships had directed us. So I have.
The first question will be that instead of keeping it as a petition of 1985.
Yes, your lordships.
What should we? How do we caption it?
Lordships, I have suggested that.
Yes.
It's at page 7.
Page 7.
Page 7. second last suggestion. what I've suggested is that the present writ petition may be converted to suo motu proceedings on air pollution under order 38, Rule 12(1)A of the Supreme Court Rules 23. Instead of 1985 hanging like a shadow over us, Lordships. So, and Lordships had asked for suggestions. So we have actually consulted, as your Lordship's direction, we've consulted all the stakeholders, including the ASG and the state councils. So what we are trying to do is we are trying to weed out the infructuous applications.
Yes, that was the second issue.
Yes, your Lordship.
So I think all of us are probably on the same page as far as the recaptioning.
Yes.
And a kind of rejuvenating with a different, I think, note
Yes.
and heading of these matters.
And Lordships will also added them on the compliance of your Lordship's orders, because your Lordships on policy issues, the broader framework, your Lordships may set, but for let's say, Lordships may set, and for compliance of those orders which have already been passed by your Lordships, that may be sent to the High Courts.
Instead of High Court, Lordship may consider NGT because these are NCR issues. So Delhi High Court may have difficulty for the rest of, there are three other states.
Only the Delhi matter, this
Lordships, the writ jurisdiction matters in compliance. Your Lordships knows that. So in NGT has passed numerous orders in the past that NGT has not been able to implement it. And that's the reason your Lordships have been taking this matter, because it has not been implemented under orders of NGT.
That's why we are saying that if this matter continues with the Supreme Court only,
yes,
with us only,
yes,
then it may be better because
because it involves Rajasthan, Haryana, UP.
There are some state-specific issues which can be restored to the High Courts.
Yes.
But this issue, because in a way, it deals with multiple states.
Yes.
The NCT of Delhi is there, Haryana is there, Rajasthan is there, and UP is there.
The bigger picture has to be in the Supreme Court, your Lordships.
So this matter, as on principle, we continue with Supreme Court only.
Yes. And Lordships, the other, the case management issues also I have flagged, your Lordships. At page 5, para 7.
So the first part we complete like this. We'll pass the radar. The instant petition that was filed in the year 1985 involves continuous mandamus issued by this court for the purpose of controlling, for the purpose of prevention, controlling, and management of the high pollution levels and other related issues, namely the drive against toxic air in the National Capital Region. It seems that though the petition was filed in the year 1985, the momentum picked up in mid-90s when a slew of orders were passed on VIPUL of pollution, including the introduction of hard emission standards from a conversion of public transport to clean fuel, augmentation of public transport, and capping the age of vehicles, etc. As well. Various interlocutory applications have been preferred from time to time, raising different issues, some of which have been, most of which have been filed, and those have been disposed of with certain directions from time to time. On the previous date of hearing, the parties were adamant that that this is the high time when the exceptional proceedings from a particularly of the year 1985 ought to be formally disposed of. It was suggested in light of the fact that none of the issues that still survives originated in 1985 or soon thereafter. The challenges which this court is now tasked to resolve are of recent times, and hence it was felt that the writ petition should be recaptioned should be appropriately recaptioned. Keeping the suggestion of learned Vicus, which is fully supported by learned Business Association of India and other stakeholders, we formally dispose of writ petition civil number 13029 of 1985. No IA or MA shall hitherto be entertained by the registry in that matter. Next paragraph. Instead, the registry directed to register suo motu proceedings issues of air pollution in the National Capital Region. All the pending IAs may be assigned, all the IAs pending as of now are directed to be registered as writ petitions, and each IA may be assigned a separate writ petition number. Learned Vicus will identify.
Lordships, I'm seeking your Lordship's direction as per para 7 for us to manage the IAs. Para 7, and there are a series of directions I'm seeking.
In order to facilitate the disposal of pending IAs, learned Amicus will assist -1I, where do we say that how these are to be segregated?
Lordships, para 7, page 5. Para 7, Lordships, at page 5.
For case management and consequential disposal of the pending IAs, the recommendation made by learned Amicus are accepted, and consequently the following directions are issued. 1I, the advocate on record on the pending applications shall inform as to whether or not the respective applications have become infructuous. If such applications have not become infructuous, they are directed to assign a specific reason, failing which it will be deemed that the IA has become infructuous. The advocate on record shall inform the registry within 2 weeks. in category A are all infectious.
Admittedly.
Meanwhile,
So we have made three categories, your lordships.
ah,
One is infructuous, one is which is disputed by the party, and the third is which is
that's it. Say, the learned micros is also requested to independently identify the IAs which have become infectious.
Yes.
Then B, all such applications which require consideration on merits shall, as directed above, be assigned separate written numbers, and they shall be further subcategorized. वो मेरी प्रैक्टिस का नोट कहाँ भी ऐसे क्यों को categorized as pertaining to A, vehicular pollution, including payment of PCC, ये इसमें देखूंगा इसमें B, air quality governance, including swine flu, B, power plants, including swine flu, 4, industry pollution, including swine flu, 5, waste management, including swine flu. The registry is
9 issues we have flagged, your lordships.
6, 7, and 8 also. 6, 7.
9 also, lordships,
Nine.
with the policy issues.
9 also other policy issues that may require consideration. 9 will be.
Lordships, then we have some suggestion because your lordships have asked for it for listing. Para D after 9, your lordships, category wise listing of matters because then it's easier for your lordships to deal with one batch of matters.
The advocates on the court shall help in identifying their IAs for subcategorizing their pending IAs under the above mentioned heads.
Yes.
The registry will ensure that all the IAs falling under one subhead are given continuous numbers.
Yes.
Continuous rate numbers.
And there are some suggestions for lordship's PD disposal that advance copy should be sent to CAQM. And where CAQM is submitted to direct a report, they should circulate in advance with the stakeholders so that we don't take another date to get into the matter.
The advocates on the court will also issue advance service of their applications from now recaptioned as writ petitions to CAQM through the Office of Learned Research Solicitor General of India.
Well, it's Ms. Ruchi Kohli. She appears to
Standing
CAQM. I appear with her.
Through the officer. Next paragraph.
We'll give the name of the AOR. Ms. Trishti Mishra is the AOR.
That's mentioned through Council and AOR.
And the CAQM reports, your lordships, item F to be circulated in advance so that we come prepared with our arguments, your lordships, and not waste time.
The CAQM on its turn will ensure that all the reports are circulated in advance. At least are circulated at least 7 days in advance to all stakeholders. Enable them to be ready for effective hearing.
My lords, we will have to add, my lords, as far as possible because sometimes your lordships call us within a week. So, my lords, how do we circulate it? As far as possible, we
As
will.
far as possible.
Yes, that's fine. Lordships, G also that the states should file their compliance in chart form.
States, yeah. The states of NCT of Delhi, Haryana, UP, and Rajasthan shall file their compliance reports, stock affidavits, well, at least a week in advance and circulate among all these.
In lordships in chart form because it's easier for your lordships to read. Otherwise, it's paragraphs after paragraphs. So if they show compliance in chart form, your lordships can see it at a glance.
On a tabulated form,
Preferably, your lordship.
My lords may consider adding as far as possible.
As far as possible.
CAQM is very good at it, your lordships. It's the states which is the problem. And lordships had said that there are too many IAs. What happens is there's one IA for direction and one permission to file. So that creates a lot of paperwork. If it could be consolidated in two prayers in the same IA.
Now it's writ.
Now it will be writ. Yes, that's gone. That's gone, your lord. So this is all, your lordship. This is what I was left with.
My lords may also be required to indicate the parties in the suo motu, my lords. I think we'll sit together and give a list, my lords, of all the parties who necessary parties who are required to be impleaded.
In fact, ये जो ना पहले categorization वाला order पर implemented था, ये captioning then categorization. Then उसके बाद all the editors on the code are directed now to submit within 2 weeks. And identify their IAs as to under which subcategory the same will fall. Thereafter, the registry will renumber them as required.
And lastly, your lordship, the fresh IAs should also fall in should be filed category wise, because then again we manage all of these in subjects and then again it goes haywire.
Entertaining an IA, there will be no end to
Writ petition, sorry, lordship, I'm used to IA for a long time. The new writ petition should specify the subject.
No writ petition, IA or miscellaneous application shall be entertained by the registry under these subcategories without prior permission of this court.
Lordships.
Let them make a mention that this is what a new issue they want to file. Otherwise, it will become unmanageable affair. Post this matter.
Would your lordship consider saying that the notice will be accepted by the parties and we'll give the parties, my lords? Because these are new proceedings now. So let all councils remain AORs, my lords.
Councils are here. They know it very well. The order is being passed in their IAs only. No press notice friendly. Those who don't want to, these are all not adversarial litigation.
Yes, ma'am.
It is absolutely court friendly proceeding. If somebody wants to pursue it, so right, otherwise we will dispose of.
Yes, ma'am. And my lords, let AORs give it with copy to the amicus's office so that they can.
All the
You will need
the copies of the IA, spoke MS, etc., which are required to be kept pending, which according to their respective AOR are required to be kept pending. That have to be served in advance to the amicus curiae.
Lordship. Lordships, when your lordship says no new IA, the writ petition, then your lordships, there is urgent hearing that the state requires or others requires.
Only pertaining to the subcategories we are saying. If any other issue, new issue, they can file the writ petition.
Lordships may clarify because then the registry becomes very technical.
Lordship said the new writ petition IA pertaining to the subcategories as mentioned in para so and so above shall be entertained without prior permission. There also we are not imposing an embargo that can be entertained, but let somebody point out that some new issue is being raised. Mr. Chima, you also help us in this matter. You keep on writing books and articles about Delhi. We do some social service also.
Lord, on the 6th of March, CAQM has filed a report, Lord, 6th of March, regarding ECC, enhancement of ECC. Lord, ECC was last fixed, Lord, more than 10 years
Some
back.
person sponsored by your contractors today filed a so-called PIL. We were likely to impose some cost, but they ran away.
No, we are supporting it.
23 years हो गए आप बैठे बैठे ये तो हम एक सेकंड में सूंघ के बता देते पिटीशन में कहां से आई और इसका ओरिजिनेट कहां से हुआ your contractors who are apprehending that these toll plazas may be shifted somewhere, they got filed a PI and they think over smart and over clever that they will be able to as if you don't understand these things. PILs are generated within country also, outside the country also. We know that also. It's not that we are sitting in ivory tower. Who is funding, from where it is being funded, how it is being funded.
But this is the CAQM recommended increase.
My lords, will your lordships take the rest of the issues? ECC is one issue in that. CAQM has filed a report.
Give a report.
There are several issues. In fact, the MLFF, the setting up of the ANPR, the
MDI versus MDA.
My lords, that your lordships have already passed an order. MCD will install, my lords, the technology initiatives. This is
Well, that should be time bound.
This is ECC, my lords, that is the environmental compensation which has not been increased for last 10 plus years. So your lordships had on 21st January permitted us to come back to your lordships with a proposal. We have given a proposal. If your lordships accepted, the ECC can be enhanced.
Yes.
6th March report of the CAQM, my lords. We have, my lords, done a calculation of how much toll it is taking for the trucks to take the peripheral roads and how much it is taking for them to cross through Delhi. So to keep it slightly prohibitive, my lords, and we have also used the same ratio that
We have been able to construct the outer now. Those concept of ring road have become complete failure. That big flop.
Yes, my lords.
In this very court, I had argued in 2002. Don't go for this ring road. This will be a big failure. We are not going to respond to the answer. I was not heard appropriately at that time, as I am very big person.
Now your lordships can rectify the situation.
You can see.
Milords is making up for lost time. Milords there in a circle.
Now, in any case, you have constructed those express highways. Why? What are the some reason we understand? Like essential commodities will have to be supplied.
Yes.
There can't be any. There should not be any reason at all.
Yes.
So why the other trucks or commercial vehicles can't be diverted to that? Instead of burdening them with any cess or any liability, if they can be diverted to that,
My lords,
suppose nothing
that
to
is
be
the
done.
purpose. So if they enter Delhi, they have to pay ECC.
Which is a deterrent.
Which is a deterrent. That is why we have recommended that it be enhanced. So, my lords, existing rates, if your lordships will just quickly have page 14, my lords. CAQM report of 6th March, my lords. CAQM proposal of 6th of March, copy that.
That's what it was on record of this report.
So, my lords, I'll just give your lordships, there are two categories of trucks. The category of light duty vehicles, my lords, that is existing rate is 1400. What we are recommending is 2000. And that is category 2 and 3. Category 4 and 5, it is existing at 2600 currently. We are recommending 4000. And my lords, so this will apply to all diesel commercial vehicles entering into Delhi, my lords. And we are also recommending that now your lordships will permit this to be enhanced at a rate of 5% every year from 1st April. This can be levied from 1st April, my lords. And every year this can be enhanced on 1st April by 5%.
Now, where is that? Where is the revised rates?
My lords, page 14, if your lordships will kindly have, page 21. Page 14, para 21. We've given the whole rationale, the calculation, etc. But I'm taking your lordship straight to the proposal, my lords. Proposal is in para.
Duty you are paying 1400 to 2000.
Yes, from 1400 it will be enhanced to 2000. And for category 4 and 5, that is 3XL and 4XL trucks and above. Originally, it was fixed in 2015, my lords. And please see para 23 also, we are also recommending that this be enhanced every year, my lords, at the rate of 5%. My lords, toll is also increased, my lords. So it has to be little deterrent for the trucks to pass through Delhi.
You are proposing
5%, my lords, every year.
Lordships, the problem is that this ECC was imposed because most of the vehicles were passing through Delhi. So your lordships imposed ECC and your lordship said Eastern and Western Peripheral Expressway, and that's how they were built under orders of this court. But now even the latest data says that a substantial number of vehicles, they pass through Delhi. So this is a decongestion charge.
That's why we are saying that unfortunately the infrastructure which has been created for facilitating them not to enter Delhi and go, nobody is following that, only because in terms of mileage, it feels that 15 kilometer, 50 kilometer, 40 kilometer is longer than this one. Nobody likes that. What is the value of that? Traveling to that side.
Well, as we have put a table also at page 12, the estimated travel. Malas, this is in response to your lordship's order of 21st January, Malas. Your Lordships had directed us to work on the.
CAQM has, in reference to our order dated 21st January 2026, made some proposal for suitable enhancement of a revision of the environment compensation charge in bracket ACC at phase in para 21 of the proposal. Para 21 of the proposal is as follows. Similarly, para 20 as follows. In para 23, it is proposed that ECC rates may be enhanced by 5% every year with effect from 1st April. It would be useful to reproduce para 22 and 23 of the recommendations.
My Lords, please look at 24 also. We are requesting your Lordships. 24, so that MCD may rationalize its toll structure.
The proposal submitted by CAQ is aimed to be reasonable, just and fair. The proposal given in para 21 and 23 proposals within are accordingly approved, subject to the clarification that 5% enhancements shall take place with effect from 1st April 1927.
Lordships.
1927. Order recording.
Because there's also one small issue, because in the same order.
In addition, all stakeholders shall continue to impress upon the shall continue to ensure that the commercial vehicles and commercial and other heavy vehicles which are not required to
Pass through Delhi.
or etc. opt to travel are applied on the express highways which have been constructed to speed connectivity around Delhi, circumventing Delhi.
My Lords are accepting para 24 also.
The courts will save them from payment of the revised ECC also.
My Lords are accepting para 24 also. MCD we are recommending should rationalize their own tolls and diversification of vehicles.
Meanwhile, the Municipal Corporation well is accordingly is also directed to terms of para 54 of the proposal submitted by CAQ. So, see, as far as their toll plaza is concerned, this has to be taken out of Delhi. That's the only way out.
It is also there to put MLFF below them.
They have tried their luck through PIL. We'll have to pass some harsh orders.
The Lordship has already passed orders that MLFF and ADMR also must be put into place. In the same order, 21st January.
They have the technology in place, your Lordship. They have the technology in place.
They haven't put it into place.
Not RFID in place.
NHI and MCD are directed to work in tandem and ensure compliance of direction contained in our order of 20 January 20.
We are complying with your Lordship's directions.
In a time-bound manner, Lords. This is just a statement, but nothing is
RFID plot in single plot of the toll plazas.
The purpose of shifting the toll plazas at some suitable sites, at suitable places.
Your Lordships, I'll be happy to assist in this matter. I'll be happy to assist in this.
Next time you give us some help in this matter also.
Item 43.
Not with your lordship
permission from Gujarat, those students. Your lordship had last week issued notice for those large number of unfilled vacancies. We have served the High Court. If your lordship can keep it next week sometime, because otherwise.
Next week.
Next week.
Lord, item 49, Lord, there was that urgency. Lord, item 49, Lord, tomorrow.
Grateful, my lords.
There's the